Good morning, everybody. It's Thursday. Welcome to the Courtroom Files Live. Today is going to be a great day, unless, of course, you're in Miami-Dade, because if you're on the screen right now, you've probably done or allegedly done a very, very bad, not good thing, and you have to face Judge Mindy Glazer, who will tell you that you did a very, very bad, not good thing as she gets hangrier and hangrier. Let's spend a few minutes with her before her audio goes to complete garbage, because that's what happens there.
The attorney, either she's handling it or she knows who is, so I can go ahead and get that ball rolling.
Christine Hernandez, Division, Courtroom 2.
Okay.
Or you could contact the chief of narcotics because it.
Gotcha. Thank you.
Sure, you have a good lawyer. Listen to what he tells you. Good day, sir. Thank you.
Bye, Judge.
Next. Where's his case? What's your case? Case was first. What's yours? Dominique Hodges, that's next. Then your case.
He's here, yeah.
Then I need Cecilio Martinez after that. Good morning. Mr. Hodges, you were arrested. You're Mr. Hodges, you were arrested for possession of a firearm, weapon, or ammunition by a convicted felon and possession of cannabis. Your attorney is present. Good morning.
Good morning,
State
Judge.
your name,
Peter
please.
Heller on his behalf, Judge, and I have reviewed the arrest form. There's no PC argument, maybe a viable motion to suppress, but it's for another court, another day.
All right. What do you want me to do with the cannabis? You want an ROR? You want a dollar? What do you want for
As
cannabis?
low as possible, Judge.
Well, I can do an ROR or a dollar.
Okay.
The state has no objection. He had less than 20 grams of cannabis. Count one, there's probable cause for possession of a firearm by convicted felon, $7,500 bond. Count two, possession of cannabis, ROR. You have a good lawyer. Listen to what he tells you. Thank you.
Thank you, Your Honor.
Nice to see you. All right, now we Cecilio Martinez.
Good morning, Your Honor.
Morning.
Scott Saul on his behalf, and also he
Hello.
has a family member in court.
All right, page 10. Good morning, sir. You were arrested for trafficking in fentanyl, sale, solicitation for the sale of amoxicillin, and also possession of cannabis. So your attorney's here. Good morning. Anything you want to say?
This is a sting buy bust operation, so I'm not going to challenge probable cause. But I would suggest Mr. Martinez has contacts with the law. I've represented him on many of them. He's always showed up to court. He's always been cooperative. So I would respectfully ask, I think a $50,000 bond would be a fair bond.
State filed a motion for pretrial detention.
Because it's fentanyl.
What?
Because it's fentanyl.
What's the, it doesn't give, it's 9 grams of fentanyl. Yeah, I think I gotta hold him. It's trafficking in fentanyl. You gotta see the division judge. I think it's Judge Christine Hernandez.
Yes, okay.
So what's going on? There's probable cause for the charges of trafficking in fentanyl. So that the state filed a motion for pretrial detention pending final hearing. And because it's fentanyl, I'm required to grant it because it's a trafficking amount. It was 9 grams. So you're gonna have to see a judge tomorrow. It's gonna be set tomorrow to see if you can be given a bond, or the state will set a date to have a motion, the final hearing heard on the state's motion for pretrial detention. And so count one is no bond for trafficking in fentanyl. Count two, there's probable cause for solicitation for sale of amoxicillin, which, what do you want? $1,000?
Yes, please.
$1,000, count two. And count three is possession of cannabis. You want a dollar or ROR?
ROR, please.
ROR count three. All right, thank you. You have a good lawyer. Listen to what he tells you. Thank you. It's got some. Here. Here. No, he's here. Okay. If there's any lawyers I forgot, type your name type your name in the chat room. We're gonna finally start on page 1 with the ladies, Tabitha Alonzo. I don't really see ladies with the people who are here. Want the ladies, female. What if it's somebody who? Okay, I'll start with the females. Let's see how. Sometimes there's people that are, I don't want to insult anybody. Good morning, this Miss Tabitha Alonso? Ma'am, you were arrested for dealing in stolen property from October 6th and burglary to an unoccupied conveyance and grand theft from October 7th. I will appoint the public defender's office for you. I need a moment to review the arrest affidavits for probable cause. This involved the theft of vehicle rims and tires. So there are three suspects acting together, wearing facial coverings to steal rims and tires. The same vehicle. Let's see, they're arriving and fleeing in the same vehicle.
So the red Honda Civic is her car.
I can't hear you.
So she's associated with the red Honda Civic.
Yes, she is. There's probable cause on dealing with stolen property on F-25-23090, $7,500 bond.
Did you find no probable cause for that charge? There's nothing indicating that she posted anything.
It did. It says it right here.
There's a co-defendant. They have them mixed up the way they have that paragraph.
The profile associated with the rims and tires being sold on Facebook Marketplace belonged to a woman named Tabitha Alonso.
She's the co-defendant.
It says, additionally, co-defendant posted about a red Honda Civic on her Facebook page and displayed her Florida license plate. And that it confirmed that she's the owner of that Honda Civic.
The defendant's her boyfriend.
Huh?
So she's the listed co-defendant. They're referring to her as the co-defendant.
Right, $7,500 bond.
Judge, Miss Alonso does not have funds for a bond. I don't see any prior history for her. She's lived in Miami all her life. She takes care of two small children at ages 2, 4. Honor consider pretrial services.
I'm reading the next affidavit. Right now, no. I know there's a lot of victims involved who went to their cars and had no tires or rims and probably put the car on a box.
There may be more charges forthcoming based upon what was found as a result of the search warrant and a further investigation into
Let
similar
me read this
cases.
other case though. No, she was cooperative. But it's talking about burglary and grand theft. It says she admitted being driving during the thefts. I guess she's charged as a principal. On this case, F-25-23099, count 1 will be $1,000, count 2 will be $1,500. So I lowered the bond in this case. Good luck to you. Next, she'll have to go see the division judge if she can't afford a bond. Charlene Laura. Page 1. Good morning, ma'am. You were arrested for battery on a law enforcement officer, resisting an officer with violence. It was 2 counts of battery on a law enforcement officer, disorderly intoxication and trespass after warning. Public Defender's Office is appointed for you. So she's intoxicated and trying to buy wine with her friends, it says. So they refused to leave the island. They gave him a trespass warning. She says she started waving her hands and fingers near the officer's face, entering the personal space. All right, she ignored the commands to step away. She was aggressive. Let's see what else. She resisted by swinging her arms and striking Officer Rodriguez on his legs with a closed fist. And she was also kicking at Officer Rodriguez and Officer Coelho. Guess you know what the moral of this story is? Don't drink alcohol because it looks like you got drunk and you didn't know what's going on and then you get arrested for all this. You're ordered to stay away from Milan's Market at 80 Curtis Parkway in Miami Springs, Florida. You're not allowed to go to that store and you must stay away from there. Do you understand?
Yes.
You ought to get yourself to go to NA or AA meetings that can help you so that you're not addicted to alcohol and you stop using it. You'll be much happier. She has no progress. I guess maybe they'll give her pre-trial.
State's requesting a bond, maybe reduce it a little bit in light of the no priors, but she was striking the officers.
She sounded like she was drunk, flailing her arms and struck him, but she did kick an officer. I don't know. Are you working, ma'am?
No.
So what do you do all day?
I'm working at opening a Pilates business.
You're what?
Working on opening a Pilates business in Miami
A
Springs.
Pilates. That's good. Those instructors do very well. But you know what? To be a good instructor, you got to lead a sober life. You cannot drink alcohol or wine because how are you going to run a business if you're so drunk you get arrested and locked up in jail? That's just something to think about. You're 24, you're young, you got your life ahead of you. Stay out of trouble. I'll give her pretrial alternate bond, $2,500 count one, $2,500 count two. Count three is $1,000. Count four, disorderly intoxication, $150. Count five, trespass after warning, $500. Have a nice day. Next is Diana Martinez, page 1.
Yeah, no, she was here, wasn't feeling well. She requested to go back.
Okay.
Let me see.
PC was found yesterday.
All right. What do we find PC possession? So reset it
Yes.
usual, or
For corrections, you'll see if she needs to get checked out. If she needs to go to the clinic.
it's fentanyl.
Yeah.
Or she may need to go to the clinic. So it's reset for the afternoon.
All right, good morning once again, everybody. Happy Thursday, or Friday Eve as we call it here. Welcome to the Courtroom Files Live. Let's stick in Florida, but let's go over to Wade Mercer. Say good morning to him.
Mr. and Ms. Adams, good morning. You're here because I reviewed the fugitive cases after 15 days. I think, Mr. Adams, you resolved the misdemeanor sentence, but I agreed to go ahead and let you go serve that sentence if that other state picked you up. I believe it was the state of Kentucky. They have 30 days to pick you up. Mr. Rushing is here in the courtroom on your behalf. Ms. Adams, I'm just letting you know that he's here in the courtroom. Mr. and Miss Adams, listen to Corporal Drown or Sergeant Gross. One of them is going to tell us what we're hearing from the state of Kentucky as far as transport goes.
Your Honor, we contacted them last week. They contacted us again. They did say they were coming to pick up.
So, Mr. and Miss Adams, they have 30 days, and it's a hard deadline. It doesn't get extended, not even by a day. They have 30 days, and that 30 days began when you signed that waiver in the presence of a judge. So I want to ask the jail on the 31st day after you sign the waiver to release you. If you haven't been picked up, they're still saying they're going to come and get you. Mr. Adams, do you have any questions?
No, sir.
Miss Adams, do you have any questions?
No.
All right. I wish you the best. Mr. Rushing, do you have any questions, sir? Her dogs are okay. Mr. Rushing said your pets are okay. Okay.
Thank you.
Thank you for coming, Mr. Rushing. We have Quantavious White. Mr. White, good morning. Mr. White, you're here for a charge of grand theft motor vehicle. Mr. White, I've read the complaint for this probable cause. I've also looked at your criminal history, Mr. White, and it's fairly lengthy. Mr. White, so you're going to be a bond candidate, most likely. I think you're entitled to a bond because as far as I can tell, you don't have any charges pending and you're not on any kind of bond already. Mr. McDaniel?
Judge, I mean, I just in all honesty to the court now, he's on bond in Gaston County in 24423 CF. I know you'll find out it later this morning. So, I mean,
I was basing that on his pretrial release sheet, which says, do you have any charges pending? And the answer is no. So, Mr. White, give me a second to look into that further.
John,
I did look at the criminal history and I didn't see a recent arrest, but let's see what we got going on. I'll do a statewide search. It won't take me just a minute.
All right.
Mr. Mitchell, you were saying something?
Oh, I was just going to ask what that case number is, but you'll say it when you find it.
Let me figure out what's going on.
24423.
Yep. Gaston County.
So, Mr. White, the question becomes, were you on bond when this charge allegedly occurred? And that's what I'm going to look at here in just a moment.
He was.
So this grand theft allegedly occurred on 10/22, which would just be yesterday. So almost certainly, if you're on bond now, you would have been on bond yesterday. Let me check the date of birth on that Gaston County case, make sure it all matches.
Judge, a lot of those cases I noticed they have April 6th and April 3rd, kind of switching back and forth, but his birthday's April 3rd.
It is in a different circuit, so it's taking a few minutes longer than normal. All right, so there's the arrest report. And on the actual arrest report from Gaston County, it does have the same date of birth. Well, it does say April 3rd, but it's the same. Actually, hang on a second. Something's not looking right. Mr. White. Well, there's a different driver's license number, but you get a different driver's license number now when you get your license renewed. So let's see if there's something else I can look at besides driver's license number.
There's a social security number.
There's a social on today. Let's see if there's a social on the other complaint. There is. And the social.
We're not objecting.
The social's the same. So, Mr. White, it does appear you're already out on bond for the other county. So what I'm going to do is what I always do in those kind of cases, or almost always. I'm going to hold you 7 days, Mr. White. I'm going to ask Mr. Mitchell to notify the authorities in Gaston County of the new arrest, and they'll have 7 days to seek a warrant if they want to and see what the judge over there does. So your bond here for today is $10,000 cash or surety, but no bond for 7 days until we hear back from Gaston County or the 7 days expires, whichever happens first. Mr. White, do you have any questions?
Is there no contact with the owner?
Yes, thank you, Mr. Mitchell. There is a condition of no contact with the alleged owner of the grand theft. And I'm going to ask the jail to give you a notice for your court date in Jackson County. And when would that be?
Still the 4th?
Still be November 4th at 8:30 will be your court date in Jackson County. But I'll see you in 7 days before the end to see what's going on with Gadsden. Any questions, sir? All right, sir. Wish you the best.
Judge, I will go ahead and I guess bring it to your and John's attention. I've run into situations with Gadsden County and bond revocations before. It's not through lack of trying, but sometimes they are very slow when it comes to revoking the bond. So
they generally don't, and I've already advised him that. And they generally don't revoke the bond, so we'll see what happens.
Okay, that sounds good. Deanna Chamberlain. Ms. Chamberlain, the first thing I need to do is get your name spelled right because I've got it spelled two different ways. Your mother's in the courtroom. I believe your last name has one A. Is that right?
Yes. Yes, sir.
And the jail sheet today has 2 A's, Corporal. So whoever typed the jail sheet, I think that may be in your system wrong. But if y'all can make that match, that'd be great. Ms. Chamberlain, you're here in Jackson County case 25-441 for the charge of petty theft. There's another count that I don't have the case on the second one.
24558.
24558 also petty theft. Ms. Chamberlain, I'm going to appoint the public defender's office to represent you in both these cases and ask that you listen to Mr. McDaniel, your attorney.
Jake's offer still 60 days or?
No, after I spoke with you, I spoke with Ms. Rhonda, and I even spoke with the judge, and we're agreeable to go on the probation given the circumstances of the Bay County case.
Your Honor, we're going to enter plea of not guilty in both the cases. The understanding, enter plea of no contest. Enter plea of no contest in both cases. Understanding should be sentenced to 1 year, 11 months, 29 days probation, $370 fine times 2. She'd only terminate on the cases if she gets everything done. She has signed her plea waiver form, waiving the right to jury trial and call witnesses. So Jake, I'll let you put those numbers of the restitution. So.
Okay, give me just a second, because there's also some review cases that.
I think you gave me a total number of $697.31, but I didn't know if you needed them broke down in each case or not, or.
That is the total of all the cases involved. There is also a total of $101.80 that is joint and several with her co-defendant.
So $101.80 of it, your mother, when she pled, said she was going to pay that, but the rest of it is solely applied to this, Ms. Chamberlain, correct?
Yes.
Okay.
And you want me to put the MRB cases on there?
The numbers, if you have the case numbers, would be great, yeah.
And since she is entering probation, the state will not file on the MRV cases of 25446, 25497, 25500, 25501, and 25504.
Ms. Chamberlain, did you hear that agreement, ma'am?
Yes, sir.
You have any questions about that agreement?
No, sir.
And is that the plea that you would like to enter, ma'am?
Yes, sir.
Ms. Chamberlain, I'm going to accept your plea of no contest of these 2 cases. They are case number 25-441 and 25-558 In those cases, I'm going to accept your plea of no contest, withhold adjudication of guilt, sentence you to 11 months and 29 days probation on each case concurrent. That means they're both running at the same time, $370 court costs and fines imposed. In each case, because they're allegedly occurred on 2 different dates, the state's agreeing not to file the case numbers Mr. Mitchell placed on the record. You'll have the standard conditions of probation. You'll also have a condition of possible early termination if you successfully complete half the probation and get all restitution paid. And like Mr. Mitchell said, $101.80 of that is joint and several with your co-defendant. Okay. The rest of it is entirely your responsibility. She's not involved in those other cases. Ms. Chamberlain, any questions?
No, sir.
There is a condition of no contact with Walmart. I don't know that was said. Do you understand that, ma'am?
Yes,
you still
sir.
want to enter the plea knowing that condition's there?
Yes.
You still want to do this,
sir.
right? Okay.
Yes.
So let me tell you what's going to happen next is they're going to let you get dressed back in your regular clothes. They're going to let you use the phone if you need to. You may not need to. We're going to find out in just a minute. Then they're going to bring you to the probation office because that's where the probation officers are at here at the courthouse. When you get here, Ms. Chamberlain, Mr. Goodson's off again.
Okay.
Mr. Goodson never takes off. I was being sarcastic. Mr. Goodson's off, so Mr. Ham will meet with you when you get here. He'll go over the probation order with you. He'll give you a copy of all the rules in writing. He'll give you a chance to ask any questions, and then you'll be free to go. So, ma'am, the question for you is, I'm talking to your mother, are you going to be able to pick her up?
Yeah, I'll pick her up over there.
You pick her up at the probation office in 30 to 45 minutes. She should be here downstairs. Okay. Your mother says she's got transportation covered for you. She'll be here to pick you up. You have any questions at the jail, Ms. Chamberlain?
No, sir.
In the courtroom, Ms. Chamberlain? All
no,
right.
Sir.
Thank you. Wish you the best, ma'am. Thank you for coming, ma'am. All right, so Mr. McDaniel, Mr. Mitchell, I know there was one thing that we discussed by email or text yesterday we were going to talk about, but we can do that after we get off of Zoom or YouTube in case someone else needs that connection. Anything else on record, Mr. McDaniel, or on YouTube?
No, Your Honor.
Mr. Mitchell?
I was just going to say if we could just talk about a couple of the cases that are coming off the arraignment docket on Monday, like.
All right, as they're wrapping up there, I'd already planned on going to Judge Simpson, but I've just been alerted in the chat that there's some SOVSIT thing that happened there. So we're going to pick up his court from pretty much where it started, and we'll see when that comes up. FYI, speaking of SOVSIT on tonight's sidebar, that is actually the topic of discussion. So if you're into that sort of thing, or even if you're not, join us. Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel.
Public defender. A lot of people don't believe such a conflict exists. People make this waiver in avoidance of all doubt.
Thank you. Mr. Brown.
Good morning, Your Honor. Warren Brown, Deputy Chief Public Defender. We likewise do not believe any conflict in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
And thank you, sir. And the court, for its part, also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People's State of Michigan versus Jacqueline Jones, Washington.
Good morning, Your Honor. Ashley Lonnie Feltus with people.
We're ready in that matter, Your Honor. Warren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Jones, Washington, who appears by...
Ma'am, could you state your name? Oh,
Jacqueline Jones, Washington.
thank you. All right, what
today's date and time set for a competency review hearing. Has it received any updated information?
I do have an October 16th court indicating that she is not competent to stand trial and that she will not attain competency within the time afforded by statute. You received that?
We have not received it.
People received that?
I have 3 files to check, Your Honor. Let me see. Oh, it looks like it got entered late yesterday afternoon.
Interesting.
I was by later than this.
We have a 2-week adjournment, Your Honor, for time to review that report and make a decision about how we're going to move forward with the cases.
I'm fine with that.
I think we kind of have to do that. Yeah. Oh, what's the 23rd? November 6th. So competency hearing will be adjourned to November 6th, 2025, 9 a.m. Bond will continue on this.
Thank you very much.
Court does call the case of the people versus Lejean Banks.
We're ready in that matter, Your Honor. Oh, yeah.
Good morning.
Good morning, Your Honor.
Your end's in this seat, but okay. I just thought I'd point that out. She was complaining that you like pushed her out. I don't know, but we'll figure it out after the docket. All right.
And good morning, Your Honor. Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Lejean Banks. Mr. Banks, could you state your name for the record, please?
Lejean Banks.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
All right. What facility is he?
Parnell. Is that right, Mr. Banks?
Yes.
Need more time. I'm going to have to go 19 days out instead of the 12. All discoveries complete.
To our knowledge, Your Honor.
All right. And would the we're going to be on. Would the people have to? Oh, that's going to be it. Okay. That week, I can do the 10th or the 13th.
That's starting over, Your Honor.
Yes.
The 10th is fine with us, Your Honor.
What?
I think the 10th should be fine.
We can be ready that day, Judge.
You can. Good. All right. Preliminary examination in this matter will be set in person for November 10th, 2025. 9 a.m. before, that's a Monday, so that you're aware.
Okay.
And that will be before Judge Valvo.
Thank you, Your Honor.
All right, and so I should, thank you, sir. Bond will continue. And so counsel, since you guys are setting up so that you know, and it really won't bother us so much for this week, that week, because the Tuesday is Veterans Day, we have an odd split. So what will happen is I will handle, they will be set the 10th before Judge Valvo that week. But also on the 13th, on Thursday, Judge Barr has to come over that Thursday at 10 a.m. to handle prelims. I will also on that Thursday be handling the PCC docket and also do some carryover prelims.
Awesome. Thank
So
you.
it's
Your Honor.
all hands on deck. Because that's how we do it in Washington.
That's how we do it.
All right. Court calls the case, People versus Dundado Kevin.
We're ready in that matter, Your Honor.
Ashley.
Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Danteo Cavins. Mr. Cavins, please state your name for the record.
Danteo Cavins. Thank you, sir.
Your Honor, today is the date and time set for the probable cause conference, keeping in mind that the prosecution has to writ him here. We're asking for the earliest available date for preliminary examination. We do believe that we have.
Well, he's in Livingston, so I can set it on our normal time schedule. I don't think that, will that work for you guys or?
We will try, Your Honor. I'm not sure where we're at with Fritz right now.
What, you're not?
I'm not sure where we're at with Fritz scheduling, if it's gonna, I've not dealt with Livingston that much myself, so I'm not sure, but we'll try.
Alyssa's doing it. She'll get it done.
She's fantastic.
I know. She will hire a bus and put them on it. That's what I hear. But anyway, here's what we'll do. And maybe so we don't run into a conflict on that. And also because of other reasons, maybe I'll go to that 1 week out. Are you, sir, are you set to be released from there anytime soon or? No. No? All right. Discovery being complete. Why don't I do this? I'll set this one preliminary examination in person for the 13th of November, 2025 at 10 a.m.
10 a.m.
That will be before Judge Barr.
Thank you, Your Honor.
All right.
Thank you.
Do it that way. All right. Thank you, sir. On continue. Thank you. Court does call the case People versus Thomas Basher.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Basher, who is here to my right.
Your name, sir?
Thomas Basher.
What are we doing?
Your Honor, I would ask the court to adjourn this matter briefly. We are endeavoring to get Mr. Basher released to treatment. There is a matter in 14B. I think we'll be able to get that pushed through and get it done in the next couple of weeks.
Probable cause conference will be adjourned November 6, 2025, 9 a.m. Bound continued.
Thank you.
Okay. Thank you. Case of the People versus Theophilus Smith. Two cases.
Ashley Phelps for the People.
Theophilus Smith.
Yes,
I've got you, Mr. Smith. I'm waiting on your attorney. Whose case?
Yeah, who is the attorney?
Mr. Brown's case, Your Honor.
Yeah, I would like to fire my attorney immediately. I like to fire my attorney, fire all representation.
All right. All right. We'll get to that in a minute. Maybe he knows already, which is why he's in here.
Sorry about that. Okay. Warren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Smith.
So that you're aware, you weren't in the courtroom. Mr. Smith did identify himself, so I'm not going to ask him to do that again. And he indicates that he wants to fire all his representation.
I understand, Your Honor. Has the court received an updated competency report?
October 22nd.
Yeah, I speak on that because I'm representing myself.
The report, the last report I have is from July, but it was
No, the only report,
marked that we received it
Simpson, the only
on
conversation I took was
October
on February
22nd, but
27th.
I don't know
February
that.
27th.
Okay, Mr. Smith, we both can't talk. Okay, I'll hear you, but we both can't talk right now. All right.
Your Honor, we have.
But I don't know if that, so to finish that thought, I don't know that this is an updated report because it's dated July.
Right.
Maybe you have a 2-week adjournment so we can try to figure out what's going on.
Weeks?
So I will say.
No, one more? No, go ahead.
I will say this for the record. Your Honor, I believe the last report has indicated that Mr. Smith has not yet gained competency. So I'd ask the court to not fire me from his representation.
To not what?
To not fire me from.
No, I'm not. Yeah.
Thank you. Thank you.
You already knew what my decision on that was going to be. What I'm going to do, Mr. Smith, is I'm adjourning your competency hearing. We need to get more information, and then I can act on whatever you may want me to act on. But yes, Mr. Smith, what do you want to say?
I would like to fire Lauren Brown if I need to get representation. Me and my mom, we got plenty of money. We can hire somebody to represent me. I will no longer want a public defender like him. I do not want him. He haven't been to see me. He don't know none of my angles. He don't know anything. And first of all, I do not need a competency exam for a $1 prohibited fire act case.
Well,
the case is arson. It's only a case that I burned the box. It was only a $1 box that got prohibited. It was a prohibited fire act. The smallest.
Okay,
I
so
a competency exam for that.
Smith?
Okay, so Mr. Smith, I can't do anything till I get that report.
Well, can I speak on bond then?
So
Because I think it's ridiculous the way I'm being.
Mr. Smith, since I can't do anything, I'm not going to do anything. I understand what you're requesting. I get all of that, but I need an updated report to try to figure all of that out.
But the thing about it is, I
heard
never wanted a competency exam. These
I know you don't.
These lawyers are doing what they want to do.
Okay.
Nobody's communicating with me, and they're doing what they want to do. I wanted to speak on bond. Ain't nobody talk about when I'm getting out of this place because I'm being.
Well, you're not helping yourself with regard to that argument. Yeah, that kind of close that. So I'll adjourn this to November 13th. Why not? 2025, 9 a.m. It'll be a good week. Bond at this point will continue. Thank you. Thank you, Mr. Smith. We'll see you in a couple weeks.
Thank you, Your Honor.
Court calls the case of the people of
Entertaining, but not the Sovcik case that we have been alerted of. So it's only going to get more interesting, I think. So let's continue with Judge Simpson.
Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Davis.
You guys have to move because I think Mr. Davis is trying to get up here.
Who's approaching?
Your name?
Aaron Davis.
Thank you. You're asking for an adjournment?
Yes, there's some video discovery I need, Judge.
All right. You'd be able to get those to you so we can go in 2 weeks.
I didn't hear what you said. I need the video discovery.
Video.
If it hasn't already been tendered, Judge, we certainly can get it.
Probable cause conference in this matter will be adjourned to, actually, I'm going to do this, November 13th.
Can we get the 6th, Judge?
You could, but you can't do the 13th?
No, the 6th would be better.
November 6th, you don't usually get to pick your dates. You got to be here if you're going to be on this dock.
I was here today, Judge. I'll be here on the
Finally, yes, I know. November 6th, 2025, 9 a.m. Bond continue.
Thank you.
False case, people versus Dontrell Smith.
Have to spell this for the people.
Oh boy, here.
Morning, Your Honor. On behalf of Mr. Smith. Mr. Smith, can you please state your name for the record?
Bill Smith. And she saw. Go ahead. What are we doing?
We're just asking for a short adjournment, Your Honor, to start plea negotiations with the prosecution.
Probable cause conference will be adjourned November 6, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Jarrell.
Jarrell.
Colorado on behalf of Mr. Daryl Jarrell. Mr. Jarrell, please state your name for the court, please.
Good morning, Judge Simpson, Daryl Jarrell.
Welcome back.
Right, thank you.
And Your Honor,
so that we're clear, has Mr. Jarrell taken care of his other warrants?
Have you taken care of your
I
warrants?
have. I've addressed all
You
of them.
took care of the, okay. I just want to make sure because we don't need another thing like he did.
Yeah,
last
thank
time.
you. Thank
It's
you.
on top of everything.
Trying to avoid that subject.
Yeah, well, I am too, but you know, you started it.
The confrontations I've had over there.
Well, you started. I didn't know why. I was trying to be
Very
nice to him.
humbling experience.
What did you say?
Very humbling experience.
Yes, it was, but we got past that. But I know that at some point you didn't appear on those, and they were warrants, and I wanted to make sure they're clear. They're clear
Yeah.
for you. Okay,
So
good.
Judge, it sounds like me being appointed yesterday, I missed some excitement on this one. I'm also missing some.
Oh, there's a video.
Oh. So I'm sure it's viral.
That's okay. He can get it to you. No,
Yeah, that's some homework for you.
he's gonna
I
just
don't
shake
know
his head.
nothing.
Don't
Exactly. Judge, we're just asking for an adjournment at this point. I was appointed yesterday, so he discovered
Got it. Okay. So adjourn the probable cause conferences, but Mr. You're doing okay though.
I'm on the right track now, Your Honor.
All right.
Thank you.
Probable cause conference, November 13th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
I'll meet you on the hallway.
Court calls the case, People versus Jeffrey Williams.
That's votes for the people.
Judge, short shall feature Assistant Public Defender on behalf of Mr. Jeffrey Williams, who is approaching the podium. Mr. Williams, when you arrive, what's your name?
Jeffrey Williams.
Thank you, Judge. I have spoken to Mr. Williams, and we are attempting to get this matter resolved. My understanding is that Mr. Williams had previously been referred to mental health court, and I think a request consideration was filed with their court. So we're asking for an adjournment to find out the status of that, and if not, to try to find another resolution. So 2 weeks.
Right. Okay. Do you think you'll get an answer in a couple of weeks?
I do, Judge.
Okay. So probable cause conference, November 6th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge.
Thank you. Take care, Mr. Williams. Court calls case, People versus LaShawn Charles.
Butter Assistant Prosecuting Attorney.
I'm telling you.
I was just gonna, I told you how I'm gonna handle it. I'm just waiting. I don't know where you went, but I'm not going,
I'll be here all day, so.
That's right.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you state your name for the record?
LaShawn Charles.
Thank you, ma'am.
Your Honor, we are asking for an adjournment. We're still waiting on some additional conversations to happen regarding this case.
Adjourn this matter November 13th, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you, Ms. Charles.
Yeah. You're welcome.
Court does call the case of the People versus Dominic Kelly Payne.
That's votes for the people.
Dominic, would you state your name for the record?
Dominic Kelly Payne. Thank you.
Judge,
He's waiving.
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right? We do. Preliminary examination having been waived, defendants bound over on a single count.
Your Honor, we acknowledge receipt of the information, waive its reading. My client would stand mute.
Pending every way formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 4th at 1:30 with Judge Conklin.
November 4th, 2025, 1:30, Judge Conklin.
Thank you, Judge. Just for the record, he's already in Judge Kunke's recovery court. We hope to get this matter in there.
Got it. All right. Take care. Good luck to you, sir.
Thanks, Judge.
Bond continued. Court does call the case of the people versus Andrew Tennant.
Your Honor, good morning.
Morning. You're in the right spot, kind of.
Oh, it's on Zoom. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Tennant. Mr. Tennant, can you state your name for the record?
Andrew Scott Tennant.
Thank you. The court should have a
Waiver.
Yeah.
And sir, you're waiving your right to a preliminary examination?
Yes, I am.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
Okay. People also waive their right?
Thank you.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Thank you. Your Honor, we acknowledge receipt of the information. My client would stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
November 4th at 1:30 with Judge Conklin.
November 4th, 2025, 1:30 before Judge Conklin.
Thank you. And if Mr. Kennedy could place on the record, there was an offer extended for the waiver. So I just want to make sure that that's clear on the record for Mr. Tennant.
Yes, that is true, Your Honor. The offer was to, once bound over to plead to count 1 of children custody for criminal purposes. The sentencing agreement is 1 year in Washington County Jail, followed by 5 years of probation, additional conditions, including sex offender treatment, mental health care, by probation.
And count 2 would be dismissed.
That's correct, yes.
Yes.
All right.
Thank you.
All right, very good. Thank you, Mr. Kennedy. Thank you. Thank you, Mr. Tennant.
Thank you.
Court calls the case People versus Andrew Gendy.
Good morning, Your Honor. Andrew Santa, attorney for Mr. Gendy.
You'll have to move to that side. He's got to come up on the side.
Your Honor, I have a signed waiver here. Mr. Gendy, I need your signature there and there.
So he's waiving his right to.
Yes, Your Honor, we're waiving our PCC.
All right.
Thank you.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense is alleged or the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
We do, Your Honor.
Preliminary examination having been waived, defendants bound over on a single count. You acknowledge receipt of the information, Mr. Fanta, waive its reading?
Yes, Your Honor. Yes.
And your client stands mute at this time?
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30 before Judge Slay.
Judge who, Your Honor?
Slay.
Thank you.
I'll let her know you said who. Anyway, never mind. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Joshua Cook.
Assistant prosecutor.
Yep, I knew it was gonna happen. No, it's not. It's not. No, Miss Apple, you're good. Where's Chinaza? It can't be me. It just can't. Where is Chinaza?
What do you understand that you're doing on the case? He's going to waive it to distribute to circuit court. Okay. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cook.
Oh no, hold up. Here she comes. Here comes the queen. She is, so she's gonna go to the podium. Judge, you just wait. I'll be there. Gonna set your appearance?
In the circuit.
You ready to waive now?
Yeah, I'm just going to wait because they're waiting on my probation violation case.
Okay. Your Honor, can we pass this? He's decided he wants to waive, so I want to get the paperwork together.
Oh, you want me to pass it?
Please.
So we had to wait for you to show up.
I know.
You know that Mr. Brown could have done that. We didn't need to, okay, fine. I'll pass it.
Thank
We'll
you
get
so
all
much.
back up, sir.
Come on.
In at the bottom or screen signing from Minnesota.
From Minnesota. Court calls the case of People versus the John J. Wright.
Trevor Maybell for the people.
Tina Sachs on behalf of Anjali, right?
I think they dialed in. Okay, we dialed in from Minnesota. Okay. She stated her name. All right. You're asking for an adjournment?
Yes, Your Honor. I'm still waiting on discovery.
How much time do we need to?
3 weeks.
Standard 2 weeks? Don't get, really? Okay, so you want the 13th? Will that work for you?
We'll work quickly, Judge, yes.
Probable cause conference, Mr. Wright, will be adjourned to November 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right. Thank you, Ms. Wright.
Thank you.
Court calls case, People versus Trita Guyton.
Trevor Maybell for the people.
Good morning, Your Honor. Mary Rubio on behalf of Ms. Guyton. I'm standing in for David Burgess with his permission. Is that correct, ma'am?
Yes, ma'am.
Okay, please state your name.
Treat a guy. Good morning, Mr. Simpson.
Good morning. All right, you're asking for an adjournment?
Yes, Your Honor, we were just recently retained. I also would like to address bond when it's appropriate.
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, it is my understanding that Ms. Guyton unfortunately failed to report to community corrections, and that's what has her in the situation she is in today. But I wanted to indicate a couple things. She indicates that she did call twice early on in October, and at that time, on 2 different days, she was told they did not have the paperwork and that she needed to call back. Ms. Guyton openly admitted she did not try to make any excuses. She said to me that she simply forgot. Ms. Guyton, unfortunately, has been diagnosed with lung cancer. She has received 1 round of radiation treatment. They have found another nodule. She needs to get more treatment. She's 63 years old. She also suffers from blood clots in one of her legs. I'm asking that the court would consider reinstating her bond. She understands the importance of complying with all terms of her bond, and she knows that she needs to follow up with community corrections.
Any response?
Your Honor, I want to note that my office did intend to extend a misdemeanor offer in this case. When we're looking at the ex-jail file, it looks like she has a couple of different holds, one on a case that was pled to our RO attempted, as well as a minor misdemeanor hold out of Canton. Nothing else.
I'll grant the defendant's motion. Her bond will be modified. I'll reinstate the previous bond as set. Defendant needs to report over to community corrections. We'll need to prepare a new order for testing. You understand that, ma'am?
Yes, sir.
Thank you.
Thank you, Your Honor.
Now let's call the case People versus Antonio Cornelius.
That's about the people.
We're ready in that matter, Your Honor. Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Cornelius. Your Honor, I believe this matter was stipulated for an adjournment.
I don't have a stipulation.
Don't want to assistant prosecutor 30. I'm sorry.
Is he here?
No.
Well, I wouldn't have signed a stipulation because I got a bond violation in any event.
Okay.
So what do you want to do?
Your Honor, I would ask for a show call, but that's Mike Gaddy's thing, so I'm going to ask for an adjournment instead.
Well, I don't know what he's doing or not doing. Well, I see what he's not doing. He's not testing. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately. Court calls case People versus Alicia Allen.
Ask calls for people.
Ready, Judge? Portia Feaster, Assistant Public Defender, on behalf of Miss Alicia Allen, who stands to my right at the podium. Please state your name for the record.
Alicia Allen.
Thank you.
Thank you, Judge. We are requesting an adjournment on this matter for further negotiation, and Miss Allen would like me to address bond, please.
I'm sorry?
And Miss Allen would like me to address bond.
Gonna do it herself?
I think she wants.
She doesn't need you.
No, she doesn't really need me.
Okay, okay. All right. What I will do, I'll adjourn this matter out to November 6, 2025, 9 a.m. Yes, as to bond.
Thank you, Judge. I believe Miss Allen currently has a $35,000 bond. She is requesting of the court that the court consider a personal bond on this matter. She indicates that she is in or was in outpatient treatment prior to being incarcerated. She does hope to get this matter resolved. In the alternative, I am going to be requesting a release to treatment if the court is not inclined to grant her PR bond.
Response?
Your Honor, this is an OWI third. Her priors are from 2019 and 2024. At the time that she was pulled over by the police, she had previously crashed into at least one vehicle while traveling between 50 and 100 miles per hour on eastbound I-94 from Jackson County, coming into Washtenaw County. A 13-year-old child was also in the vehicle with her while she was operating at a .118. There is an RNO causing injury attached to this, as well as another RNO. I do not believe any change to bond is appropriate. I would even be concerned with a release to treatment, given the allegations here and the lack of compliance with lawful orders. I would ask that the court continue the bond as currently set, and we can revisit a release to treatment at a later time. But I'm very concerned about her being out of custody in any way, shape, or form in this way.
Anything additional, Mr.
No, Judge.
Given all of that, motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Court does call the case People versus Amiri David. You know, your name, sir?
Mary Davis.
All right. Take your hands out of your pocket. All right. I have PD, but I don't have, nobody got assigned to them.
This case also involves
It's Aaron Davis.
Aaron Davis, yeah. So we have Aaron Davis, but we cannot take Mary Davis.
Okay, but I don't have an attorney. I mean, the last,
Mr. Aaron Davis was with Mr. Quinn earlier.
oh, Aaron Davis was Mr. Quinn.
Mr. Quinn is here.
That case is already been called, and Mr.
I know. What I'm indicating is that so that wouldn't be a conflict for the PD.
Was he appointed or did he retain?
I have no idea. All I know is it was Mr. Quinn and not the PD's office on that one.
Aaron Davis, this is Mary Davis. Well, so we did review it. Aaron Davis was first appointed to us, so we asked to keep that one and have the others, Earl Williams and Amiri Davis, as conflicts. It appears then that Aaron Davis has retained.
I don't know if did he retain?
No, he was appointed by.
I got switched.
So whatever happened. But,
all right. So
here's what I'll do. You guys get this worked out however it's supposed to work out. But the problem's going to be is now Mr. Quinn's going to have a problem even if you tried to switch because
so what we can do is now we can keep Mr. Amiri Davis, I believe.
Okay. And then, if you can do that, then
we'll ask for an adjournment to be able to.
I'll set this on the same date. I set the other one November 6, 2025, 9 a.m. Bond continued. Thank you.
That was just.
Court calls the case of cases of the People versus Robert Barnett.
Thoughts from people?
Assistant Blood Center Dodgy Leba for Mr. Barnett. Mr. Barnett, could you state your name, sir?
Robert Michael Barnett.
And Your Honor, we're going to be requesting an adjournment. Additionally, would like to address bond.
Probable cause conference will be adjourned November 6, 2025, 9 a.m. as to bond.
Thank you, Your Honor. With regard to bond, and Ms. Barnett is currently being held on two matters. Based on my review of the police reports, it appears that those two matters arise out of the same incident. I don't know if the prosecution would disagree as to that. So I'd be asking for one of those bonds to be reduced to a personal bond if possible. Additionally, I did discuss the prior.
Why would that? I don't follow what you're saying. Why would that say there should be a personal bond?
Your Honor, can we approach for a moment?
No, I don't need your approach. I just don't understand that.
Your Honor, so two of the offenses appear to be one incident that were inadvertently charged as duplicates. So it'd be requesting for one of those bonds.
So you're saying that one's a duplicate?
Yes.
So he doesn't really have that case. Do people agree on that? Or?
This is the first I've heard, Your Honor. Mr. Lebo and I did not have a chance to discuss that before the matter was called. I don't know. I would have to double check. I'm not 100% sure. I would indicate though that at the time that the possession case got picked up, which is 25F55793, he was in bench warrant status for the receiving, concealing stolen motor vehicle. So I would be opposed to any change of thought as he previously failed to appear on the pick up the case.
And I did want to address the previous failure to appear.
Okay, I see that it looks like the case ending in 1406 and the case ending in 965. I don't know if they are or if there were two motor vehicles, but they, on the face of it, could be.
They could be.
But I'm not going to have. One says a pickup truck, the other specifies a Ford F-250. But I don't know that they're the same. Mr. Lebo, you had to talk to counsel about that. They can't be surprised by that.
Yes, sir. And I did send an email. My understanding is that they may have reviewed that, but I believe that the email may have gone to a different prosecutor.
Okay. All right. What's the other explanation regarding?
In regard to failure to appear, Ms. Barnett has admitted to me that he was suffering from fairly severe substance use problem at the time. He tells me that he has since completed treatment at Share House, and he attends meetings on a bi-weekly basis, or rather a twice-a-week basis. Says he is very eager to have an opportunity to be released to prove to the court that he will be showing up in the future, and we would have no objection to a tether.
We do agree with you, because we'll get one dismissed. They do agree with you.
Okay. All right. So there'd be only two cases, but all right.
He was still in bench warrant status at the time, so I would be opposed to any change of bond.
All right. Because of that, motion for bond reduction is denied. Bond will continue on these matters.
Thank you.
All right. Thank you. Court does call the case, recall the case, People versus Joshua Cook.
And Assistant Public Defender, Chauncey Carey Action Ruby, on behalf of Mr. Joshua Cook, Your Honor.
Your name, sir?
Joshua Cook.
You're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to second court for further resolution.
Yes, sir.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over on a single count. Second round.
Your Honor, we do acknowledge receipt of the information, waive its formal reading, stand mute to the charges, asking the court to enter a not guilty plea on his behalf and set this matter for a pretrial.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea pretrial in this matter. Keep that for
December 16th at 1:30 with Judge Cumpy.
December 16, 2025, 1:30 before Judge Cumpy.
You're in front, thank you now, right? You're in front.
Bond will continue. Thank you.
Thank you so much, Your Honor.
Thank you,
You need a few-
Then he needs to sign off.
Yes.
Court does call the case People versus Jason Smith.
Well, is that on behalf of people?
Morning, Your Honor. Kristen Saxon for Mr. Smith.
Okay, he's refusing to come up.
Yes, Your Honor, which is unlike him. I just spoke with him last night, and another time before that, pleasant conversations. I'm not sure what's going on here. We were going to ask for an adjournment anyway because we're still waiting on some discovery.
All right. Probable cause conference will be adjourned November 20th, 2025, 9 a.m. bound continue.
Thank you, Your Honor.
Court does call the case, People versus Charles Davis II.
Trevor Mayville for the people.
Mr. Davis, what do you guys do? What do you guys do?
He said there's one on the video, so.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Davis. Mr. Davis, state your name for the record.
Charles Davis.
Thank you, sir.
Your Honor, I believe today's the date and time set for the probable cause conference. We do not have all of the media, so we are waiting to get that.
All right. Is that going to be sent over?
I beg your pardon, Your Honor.
Is that going to be sent to them right away? Or?
Yes, Your Honor, I've been in touch with Mr. Feaster regarding this. We have provided discovery, but I think we're going to look into a second round.
Got it.
Be missing. We can use a couple of weeks.
Probable cause conference will be adjourned November 13th, 2025, 9 a.m. on continued. All right. Thank you, sir.
13th, okay.
Court calls the cases of the People versus Mohammed Murphy.
That's thoughts to the people.
How you doing? Good morning.
State your name for the record, sir.
Muhammad Murphy.
Thank you. What are we doing? Apparently we're having a conversation.
Your Honor, we would like to set this matter for preliminary examination, and we'd also like to address bond.
Oh. This apparently doesn't carry over there. Mr. Kilowatt, I think one of these cases are yours.
Oh, yeah, that's true.
Sorry. Mr. Mohammed Murphy?
Yeah.
Yeah, I know that's you, but on case 1701, you were.
I'm not aware of it. If you say.
Well, that's apparent. I'm informing you, I signed the order that the PD's withdrawn on that case, and it's you.
You know what? It's my lucky day.
Good morning.
How you doing?
Do you mind if I ask for an adjournment so I can talk with you at the jail?
How long that's gonna be?
Well, we'll get it as quickly as possible, Judge.
No, I would rather handle this today.
Well,
because he said that it's been withdrawn.
Okay, hold on one second.
Nothing's.
All this.
I just want to go home.
Judge, I wonder if we could pass this. I can go see him in the lockup.
Please. Okay.
You being a considerate judge, you are.
Thank you.
Do you have any objection to that, Ms. Second?
Absolutely not, yeah.
All right, thank you. Okay, I'm gonna pass your case. They'll come back and talk to you.
Okay.
We'll get it all sorted out.
Thank you.
You're welcome.
More than one case? What do I?
Court, good job, Kilowald. Court calls the case, People versus Jason Campbell. All that did was postpone the inevitable. It's not.
The water system is probably trying to go deep.
Campbell.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Campbell. Like to get time on that.
Your Honor, I spoke to Ms. Deduce about this matter, and she was going to be asking for an adjournment. Mr. Campbell has a release and treatment order, and he is currently has a hold in Westland. He's set to be arraigned on that, I believe, November 6th. So both sides are hopeful that he can secure his release there, get to treatment, And then once he completes that, we can hopefully resolve this matter.
Karen Medadis on behalf of Mr. Campbell, Your Honor. Everything that APA Overwater said is correct. Believe November 6th is his arraignment date.
He has a date in Westland, November.
A Zoom arraignment that we've set up for him here in Washtenaw County Jail. We've sent in the order. Order was signed. He's also signing himself up for the Dawn Farms in.
I'm already in the
yeah.
class, yeah.
Okay.
We're just adjourning to track that and pursue.
I guess my issue would be if I set it for the 6th, are we gonna be able to do both? Or do I need to kick this out to the 13th? Would
Perhaps
that be
the
more
13th.
productive?
That will be more productive. Anyway, if he gets arraigned and gets released, then
He's on that,
the
and
adjournment,
he's
yeah.
gonna be looking for treatment here, so we can track it.
Exactly, yeah. Thank you, Your Honor.
Probable cause conference will be November 13th, 2025, 9 a.m. Found in this matter will continue. Thank you.
Thank you. I'll make the meeting, okay?
Court calls case people, well, is he in? Got it. Court calls case people versus Joshua Wara.
Cover me both of the people.
Mr. LeBeau's case. Wara.
Joshua. Thank you, Your Honor. Mr. Warren, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know.
You
the
don't
mission
understand?
bar. I'm a jailhouse lawyer.
Pardon?
I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolph Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got
Klans.
to do something. I've got to
With
do
the
something with your
MDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10
you-
times the
if
amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the fullest
I'm with you.
extent, which is
I'm
my
with you. I
right.
did that. I did the math too. Listen, here's the thing.
Mm-hmm.
I have to advise you because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom. 'cause they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
Prism to
Ann
make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount, but since it is conspiracy
Okay.
to murder, sovereign
I'm
law
with
does
you.
not
I got
exist.
you. I just have to let you know what you're charged
means
with.
I can sue for
There's
1,000
also
times the
count
amount.
2 on the complaint that
Legally.
alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes,
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of, that you abide by the rules of evidence and the rules of procedure. You understand that?
yes, Senator Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do
then all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any
on
point you do,
objective evidence.
if
A
at
bench
any
trial
point
is
you
objective
do want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial can
that's not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder and Donald Trump and Elon Musk are involved and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist because the amount of money that
I
they
don't know,
put
I've
that
not
hit
been
out
very
on
good at
me.
it, but.
And Donald Trump and Elon
oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get.
Okay,
Mack
okay, I'm
and
with you.
Chair.
I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
give
So
Donald
we would
Trump the
need more
elected
time.
chair.
The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Frederick Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't again.
Okay, but you
There
haven't
are too
seen
many
the
people involved.
You
You have a
haven't
Neuralink
seen.
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
and based on
listen.
factual
listen.
evidence, the jury
No,
trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to
subpoena
represent
phone records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Wara.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
down.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. Would they, man? I'm not gonna have the complaint that's rights have been infringed, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. No, I have to do the, no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm gonna
Yes.
give you your preliminary examination. So your preliminary
you.
examination will be set in person on,
Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
no, I
Hitler
know,
is in
but I
judicial
realize it's
court
close, but,
With Carol
it-
Conkey and East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm
Alright.
suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me
Okay, so here's what I'm gonna do.
and Donald Trump.
I don't know that we'll be able to go, given how you're
Yes,
acting.
we will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
I'm gonna set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. You know, I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
Thank you, Your Honor.
You're welcome. No, you're not really thanking me, but I get it. All right, thank you. Thank you, sir.
I am going to sue for $100 trillion. Oh my dear Lord. So, tomorrow will be my last day in this chair for 2 weeks because we're traveling across the country for my daughter's wedding. But it will not be the end of the live show. Michael Groff will be guest hosting rather for those 2 weeks. Michael, you have 100% creative control over this show, of course, while I'm gone. However, you are hereby requested and required on the 28th to go back to Judge Simpson's court and cover this as long as he's streaming it, because oh my dear Lord, that just needs to be looked at. So, yeah. That is Sav Sit meets serious mental issues. I think that is that's some crazy stuff with a threat at the end of an execution. So yeah, this is going to end up in a competency evaluation for sure. Let's tame it down a little bit. Lake County, Ohio, Vincent Collada. Let's go there.
We are present this morning in the matter of State of Ohio versus Tyler Cran, aka Talia Cran. This is case number 24 CR 1412. Present open court this morning is the defendant with her attorney, Rachel Smith. We I've had a couple hearings on this case, but we are here today for what I believe is going to be a change of plea, whereby the defendant is going to withdraw her previous entered plea of not guilty to the indictment in this case and enter a plea of guilty to 2 charges. The first being an amended count 1, amended to be attempted aggravated arson in violation of 2903.02A and 2909.02A2, that being a felony of the 3rd degree, and count 3 as indicted, grand theft of a motor vehicle in violation of 2913.02A1, a felony of the 4th degree. Count 2 would be dismissed pursuant to the plea negotiations. It's my understanding the defendant will enter a plea of guilty to those today and ask for a pre-sentence report. The state and defendant, through her attorney, have had extensive discussions about this case, mainly regarding sentencing. The state is amenable to an agreement of community control. However, at this time, there is no agreement as to sentencing, and all options are on the table until we see a pre-sentence report and have further discussions prior to sentencing.
Thank you. Smith, does that sound right?
Yes, Your Honor. My understanding of the agreement is consistent with that which the state has outlined on the record. I've relayed that agreement to Ms. Cran, and it's my understanding at this time that she does intend to enter a change of plea to count 1 as amended and count 3 as charged, with the understanding the balance of the indictment will be dismissed. I believe she'll be doing so in a knowing, intelligent, and voluntary manner.
Thank you. Were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to 2 charges here, and I'll go over those with you to make sure you understand what those are. The remaining count would get dismissed. We would defer sentencing to a future day so some evaluations could get completed, some reports, and come back at a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side's free to recommend to this court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on here, right?
Yes, sir.
All right, let's get started then. How old are you?
I was born December 13th, 1995, which makes me 29 years old.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, prior to coming into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medications, nothing?
No, sir.
Now, you would have been served with a copy of the indictment in this case. It's the document that sets forth particular charges you're accused of committing. Do you remember getting that?
I remember holding it in my hand, but I do not have it in my personal possessions. I believe it's in my...
I'm not asking if you have it with you right now. I'm just asking, do you remember getting a copy of that at some point?
Yes, sir.
And at some point you would have had a chance to look that over?
Yes, sir.
So in that indictment, you are charged with 3 counts, pleading guilty to 2. In count 1, I'm going to read that count to you. That's not what you're pleading guilty to. It's what you're charged with. It's alleged that on or about October 29th, 2024, in Madison Township, Lake County, Ohio, that you did by means of fire or explosion knowingly cause physical harm to an occupied structure, that being the residence at 6828 Middle Ridge Road in Madison Township. I'm sorry. That conduct constitutes the offense of aggravated arson. It's a felony of the 2nd degree. Do you understand what you're charged with in count 1? It's not what you're pleading guilty to, it's what you're charged with. Do you understand that?
Yes, sir.
Any questions about it?
No, sir.
Now, for purposes of the plea today, the state has agreed to amend this count to a reduced charge called attempted aggravated arson. And what that means then is that you knowingly engaged in conduct that, if successful, would have resulted in the commission of the offense of aggravated arson. And it's a less serious offense. It's a felony of the third degree. There's a big difference between felony of third degree and felony of second degree. You'd be pleading guilty to the lesser offense, felony of the third degree. Do you understand the difference there?
Yes, sir.
Any questions for me about it?
No, sir.
Now, on count 3, what's alleged here and what you're admitting to is on or about October 29, 2024 in Madison Township, Lake County, Ohio, that you did with purpose to deprive Bentley Todd Curran and Cheryl Ann Curran, who are the owner of property, that being a 2015 Honda CRV motor vehicle, that you knowingly obtained or exerted control over that motor vehicle without the consent of the owners or anyone else authorized to give consent. That conduct constitutes the offense of grand theft of a motor vehicle. It's a felony of the fourth degree. Do you understand what you're charged with completing guilty to in this count?
Yes, sir.
Any questions about it?
No, sir.
Now, there is a second count of this indictment, a charge of arson that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about that charge?
No, sir.
Well, then before I can accept your guilty plea to the two charges I just reviewed with you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, do have the right to have a trial in this case. And a trial could be to me as a judge, or I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, and that will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. And that decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. He would have what we refer to as the burden of proof. By having the burden of proof, what that means is that it is his job. He bears the responsibility or the obligation. He bears the burden of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since it's a criminal case we're dealing with, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden of proof there is in our justice system. And what that actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would be bringing witnesses to come into court to testify for the state and answer questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. She can ask them anything she wanted to within certain rules. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request this court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come into court and testify in your behalf and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
You realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. Sorry, excuse me. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Lastly, if we were to go to trial and you were found guilty, you'd have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor regarding these charges you're pleading to. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll first of all be found guilty by this court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to 2 counts here. The lesser included charge of count 1 that you're pleading guilty to is a felony of the 3rd degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So if I was to impose a prison sentence, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you have to serve for that count. Do you understand that?
Yes, sir.
Now, count 3 is a felony of the 4th degree. That's the theft of the car. And that's punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, since there's 2 separate offenses here, if I do impose a prison term, I would impose a prison term on each count. And then as a judge, I have the discretion to run those prison terms either concurrent with each other or consecutive to each other. Concurrent means together. You serve both prison terms at the same time together. Consecutive means one after the other. You serve the prison term on the first count, whatever it is, complete that, then serve the prison term in the next count. You understand the difference there?
Yes, sir.
So in this particular case, if I was to impose the maximum prison sentence on each count and run them consecutive to each other, you're looking at a maximum possible prison term of 54 months, or is that 4.5 years in prison? You understand that?
Yes, sir.
Now, are you currently on probation or parole to any other courts or agencies?
No, sir.
Do you have any other charges pending against you right now anywhere?
Not that I'm aware of.
If a prison term is ever imposed, in this case, upon your release from prison, you would be placed on what is called post-release control, and sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence. In this case, it would be mandatory for the attempted aggravated arson charge, and it would be for at least 1 year, and it could be up to 3 years for the parole authority to determine that. You understand that?
Yes, sir.
And while on post-release control, if you've ever violated any of the conditions of your supervision, parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%, or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. On the attempted aggravated arson, there's a possible fine of $10,000 or up to $10,000. On the grand theft of a motor vehicle, there's a possible fine of up to $5,000 altogether. It's a possible maximum fine of $15,000. You can also be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
You could also be ordered to pay restitution in this case for any economic loss any victim may have suffered as a result of the criminal conduct you were involved with. Do you understand that?
Yes, sir.
Further, the time of sentencing, you will be classified as an arson offender, and you'll be required. It'll be explained to you at that point what your obligations will be to register as a registered arson offender, and that will require you to register in person at the county sheriff where you reside once a year, your personal information, name, social security number, where you live, etc. And I'll explain those in more detail at the time of sentencing when I'm required to do that. But you'll be required to do that annually. Was it for 10 years, I believe?
I believe that's correct.
You'll be required to do that annually once a year for 10 years. You understand that?
Yes, sir.
All right, now aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be, strike that. You could also be placed on, let me start over. When I mentioned the possible prison term, I told you it was possible. Prison's not mandatory with this charge. You're eligible for probation or what is called community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation or receive community control? It means I'll consider that. If that's what you're asking for, it appears that you are. I'll look at all the information presented, and then I'm going to make the decision that I think is the right thing to do. You understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve time in the Lake County Jail of up to 6 months, the condition of your probation. You understand that?
Yes, sir.
Further, if you're on probation, you're violating the conditions of your supervision, we would have a hearing in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could impose more restrictive sanctions against you. Or I could terminate or end your probation at that point and send you to prison at that point. And that could be for the period of time I mentioned before, up to 54 months. And that could also be consecutive to any other prison sentence you may be serving at that time for some other case, or that you're being sentenced to if there's some new case that were to occur. Do you understand that?
Yes, sir.
Lastly, when we do proceed with the sentencing hearing down the road, you're going to have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, sir.
You understand that whatever the attorneys say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along with that if I didn't think that was what should be done. You understand that?
Yes, sir.
All right, were there any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with your lawyer and have her review everything with you, the reports, whatever issues there may be, answer whatever questions you have? Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has she or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today? Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then, do you have any questions for me at this time regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No, sir.
All right, then what's going to happen now is that the prosecutor here is going to explain for me what the facts would show in this case if we had a trial. I want you to listen to that, because I'll have some questions for you about that, all right? Mr. Donahue.
Thank you, Your Honor. Before I read the facts, just one thing that I neglected to put in the change of plea paperwork was under Revised Code 292971 that the defendant could be subject to paying the reasonable cost of investigation and the process for that for the arson. So I don't know if that needed to be mentioned, but
well, I will mention that. I thought that was the case, but it's not mandatory though, right? It's up to me to decide that.
it's the court is required to send out notice to the agencies, but then as far as what the court does with that, it is discretionary.
So you could also be ordered to pay the cost of the investigation in this case that occurred as a result of the arson. Do you understand that?
Yes, sir.
Mr. Downey?
Thank you, Your Honor. Had this matter proceed to trial, the facts would have shown that on October 29, 2024, at about 3:42 p.m. in Madison Township, Lake County, Ohio, Madison Township Police and Fire responded to 6828 Middle Ridge Road for a report of a structure fire. When they arrived, they found it to be a single-family residence, which was actively on fire. That residence is owned by Cheryl and Bentley Coran, who are the defendant's parents. It was learned that Bentley had left to go to work and pick up Cheryl from the airport on that day, and they were on their way home when they received a call that their house was on fire. The fire was put out. State Fire Marshal determined that the fire originated in the basement, and it appeared initially at the time the fire was incendiary or intentional in nature. There were approximately $400,000 of damages done. As of today, the house is in the process of being repaired, but a completion date is unknown. Personnel on the scene also noticed, while putting out the fire, that Cheryl's 2015 Honda CR-V motor vehicle was missing, and that the defendant, who was also recently at the residence, was also not there. That vehicle was entered as stolen. At approximately 11 p.m. that night, the vehicle was located and stopped at the United States-Canadian border near Port Huron, Michigan. The defendant was attempting to cross into Canada and driving that motor vehicle by herself. The defendant was taken to custody in Michigan, was later interviewed by Madison Township Police and State Fire Marshals, where during that interview she did admit to starting the fire while she was at the residence alone and then leaving the residence in her mother's vehicle. This offer today, I just want to note for the record, was specifically approved by the Lake County Prosecuting Attorney Charles Coulson.
So were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, did he say about those facts he presented them? Are they true? Did you do what he said?
Yes, sir.
Very well, then, regarding the lesser included offense of count 1 being attempted aggravated arson, a felony of the 3rd degree, what is your plea at this time?
Guilty.
Regarding count 3, charging with grand theft of a motor vehicle, a felony of the 4th degree, what is your plea at this time?
Guilty.
I have in my possession right now a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just reviewed with you. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you sign it here in court. My understanding is before I came out here, you had a chance to review this document, go over it with your lawyer. Is that correct?
Yes, sir.
Ms. Smith, is that accurate? Did you read this over with your client?
That is correct,
Review
Your
it?
Honor. I reviewed the document with her and she indicated an understanding.
Is that correct?
Yes, sir.
So you understand what this document says?
Yes, sir.
Any questions for me about it?
No, sir.
It also appears that you signed the document. Did you sign it?
Yes, sir.
Ms. Smith, did you witness that?
I did, Your Honor, and I signed it as well.
Mr. Downing, you as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in court. Their attorney advised of all our constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of the lesser included offense of count 1, attempted aggravated arson, a felony of the 3rd degree, in violation of 292302 and 2909.02A2, as well as count 3, grand theft of a motor vehicle, a felony of the 4th degree, violation of 2913.02A1. Count 2 will get dismissed at sentencing, but sentencing will be deferred. I'm going to order a pre-sentence report and investigation. Victim impact statement. Is there anything else you're requesting, Ms. Smith?
Your Honor, psychiatric evaluation, and we would ask that the client be assessed for NeoCap.
What was the first thing you said?
Psychiatric.
Psychiatric, okay. The psychiatric evaluation. Okay. Bond will be continued. Is there anything else for the record then at this time, Mr. Downing?
No, Your Honor, thank you.
Ms. Smith?
Not at this time, Your Honor.
Thank you.
All rise.
Okay, friends, so I have some information for you because we discovered here that there is an arsonist registry, which we commented in the chat. None of us really knew was a thing. We thought there was only one registry, and that was the sex offender registry. But I did a little digging, and there's more than we think there is. So the arson offenders registry is a thing. It depends on the state, but for example, California, under Penal Code 457.1, You have to register with your local sheriff or chief of police if you are guilty of arson, but it is not a public lookup. Illinois has the Arsonist Registration Act, where they keep a public database of arsonists there. Several cities require convicted people with certain gun violations to register for a set period. New York and Washington, D.C. are two examples of that. But that is for law enforcement. Neither one of those cities provide like a map of where these people are. A few states keep public lists for certain drug convictions, often meth manufacturing. It is a drug methamphetamine offender registry. Most notably, Tennessee maintains a public meth offender registry via the Texas Bureau of Investigations. Violent offender registries. Some states bundle non-sexual violent crimes like assaults and kidnappings into searchable registries. For example, in Indiana, it's not a sex offender registry. It's a sex and violent offender registry, and that is a public database. Domestic violent offender registries. Tennessee has passed Savannah's law just this year, which will create a domestic violence registry, again available at TBI there. There is an animal abuser registry that's generally at the local or county level. For example, Suffolk County, New York has an animal abuse offender registry. Tennessee has an animal abuse registry, again on the TBI website there. Child and adult abuse neglect central registries. Every state maintains civil databases used for background checks and child care and elder care hiring. Example there, Nebraska's Adult and Child Abuse and Neglect Central Registry. There is a property level meth lab registry, not people, but addresses where clandestine labs were found, and that is maintained by the DEA. So there's actually a lot more out there than what we knew. One of the things I love about this channel is we learn things every day. And, we all kind of worked under the assumption of, there's a sex offender registry, but no, there's like registries for everything. So don't do crimes, my friends, because you're going to end up in a database somewhere. Okie dokie. Judge Boyd.
All right, the court is calling 2024 CR 011624, State versus Jan Hawkins, aka Jan Madura. Can I have parties announced?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura. And are you Ms. Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
All right, thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 1. We're proceeding on a lesser included of count 2.
And what are you proceeding on?
On a Class A theft.
No objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected at toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out all, we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here.
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So y'all will have to correct your paperwork.
Judge, if I may, we've done this before. We are
Not with
pleading no.
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose, having us do, we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have, at the very
That's why
least,
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings, and I make a decision on whether or not they owe it or not.
and Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well, that's where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid, or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this: if she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence, and the judge can look at that and decide that they find those documents credible and find that they are true, and
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you accept if we just simply put on that we do not stipulate to the final amount?
Y'all do the paperwork, and if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the thing. I haven't read any of the evidence, so I don't know what y'all are presenting, because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. this argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge. Okay, thank you.
So, yes, so everything needs to be reprinted and redone. Thank you.
Thank you.
All right, who's next?
Okay, friends, let's go back to Judge Collada. He's got a case with, if I heard it right, they're doing a sentencing, but then there's also a couple of other charges where there's going to be a change of plea. So this looks a little bit complicated. Let's see what's going on.
On 3 separate files. Files 25 CR 403, we're here today for sentencing. On file 25 CR 879 and 25 CR 1281, we're here today for informations. In the last 2 cases, it's anticipated by the state of Ohio that the defendant will waive his right to have his case presented to the Lake County Grand Jury, and furthermore to enter a plea of guilty to 1-count information on each file. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce these pleas. Thank you.
Mr. Watson, does that sound accurate?
Thank you, Your Honor. I please the court, that is my understanding of this morning's hearing. On case number ending in 403, we are prepared to proceed with sentencing. And then on case numbers 879 and 1281, I have had a chance to fully pre-try those matters with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss each case with my client. He is prepared this morning to enter a change of plea by way of information on those 2 cases as outlined by the state. First, Your Honor, he understands that by entering a change of plea, he will be waiving his right to have these cases presented to the Lake County Grand Jury. Furthermore, Your Honor, he understands that by entering a change of plea, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. Mr. Hemming, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes.
In regards to the 2 later cases, 25 CR 879 and 25 CR 1281, those are the cases that you have not yet entered a plea to. They represented to the court, they believe it's your desire to waive your right to have each of these cases presented to a grand jury. They're both informations, correct?
That's correct, Your Honor.
And to plead guilty to the charges in the information in each of those 2 cases, and I'll go over those with you to make sure you understand what those all entail. We would then adopt the pre-sentence report that was prepared in case 25 CR 403 and proceed to sentencing in all 3 cases. Is that your understanding of what the negotiations were between your lawyer and the prosecutor and what you want to do here today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here. So what we're going to do first is have you enter a plea of guilty to the 2 new charges. If the court accepts that plea, we will then proceed to sentencing on all 3 cases. But before I can accept your plea in the 2 new cases, I need to make sure you, again, understand all the rights you have that you give up by pleading guilty, the penalties you face. You need to make sure you understand what it is you're charged with and pleading guilty to. So I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything that I'm asking you, if you want anything repeated or clarified, if you need a moment to speak with Mr. Watson and ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Now, the questions I'm going to ask you, I'm only going to ask you them once. They apply to both cases, though. We're not going to go through them twice. there's anything that applies to one case and not the other, I'll make sure I point that out. I don't think that's going to be the case, but if that is, I'll let you know. But let's get started then. How old are you, sir?
43.
43?
Yes.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language? No. Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, did you receive a copy of the information that were filed in each of these two cases?
Yes. Yes.
And you had a chance at some point to look those over?
Yes.
All right, let's start off with what I have here. First, 25 CR 879. What's alleged here and what you'll be admitting to is on or about June 7th, 2025, in Paynesville, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this case?
Yes.
Any questions for me about it?
No.
Now, in case 25 CR 1281, it's the same charge, only a different day. It's alleged in this case, and what you're admitting to in this case, is on or about July 22nd, 2025 in Kirtland, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. Again, the amount did not equal or exceed 5 grams, which makes this offense also possession of cocaine, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes.
Any questions for me about this charge?
No.
Well, now, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, in each of these cases, have the right to have each case presented to a grand jury. So the charges I just read to you are part of what's called an information. An information is a criminal charge that's brought by the prosecutor's office without the case having been previously reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well, but you can give up that right if you desire and go forward on the charges brought by the prosecutor and the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
Well, before I can accept your plea, I need to make sure you understand, I need to make sure you acknowledge that here in open court in writing, and I have in front of me 2 written documents. They're identical, except one for each particular case, with the appropriate case number on each one. And they basically set forth what I just explained about this grand jury process, and now you want to give up that right. Before I can go forward, I need to be assured you understand this document and you sign it here in court. My understanding is before I came out here, you had a chance to review each of these documents with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this with Mr. Hameen, answer his questions?
Yes, Your Honor. I did review each waiver of indictment form with my client. I read it. He read along with me, indicated he understood it, and signed each document. And I witnessed it in front of the prosecutor, Your Honor.
Is that correct, Mr. Hameen?
Yes.
So you understand what the documents, both documents say?
Yes.
Any questions for me?
No.
Did you sign both of these documents?
Yes.
Very well. Then the court at this time will accept these waivers and make them part of the file in each respective case. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you first off, in each case, have a right to a trial. And a trial could be to me as a judge, or I listen to all the evidence, and I make that decision whether you're guilty or not guilty. But you also have a constitutional right in each case to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors will make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty of all these charges. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial in each of these cases?
Yes.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio. and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome the presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since these are criminal cases, that burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of these charges in each case beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want. Do you understand that?
Yes.
You further can request this court to issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. So what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes.
You further understand that if you did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will make it by accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, each of the charges you're pleading guilty to are felonies of the 5th degree, and each are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
And since there's 2 separate cases here, if I impose a prison sentence in each case, as a judge, I would have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means the same time, together, you serve them together. Consecutive is one after the other. You'd serve the prison term in whichever case, one of the cases first, whatever that is, and then you complete that and then serve the prison term in the next case. You understand the difference there?
Yes.
So with both cases, there's a maximum possible term of 24 months. Do you understand that?
Yes.
Now, I know you have the other case pending here. Do you have any other charges pending against you anywhere?
No.
Are you on probation or parole or community control or whatever, PRC at any courts or agencies?
Just probation.
Where are you on probation?
Here.
No, No, you're on probation.
You talking about the other case? You talking about that other case? The one that you already pled guilty to?
Yeah.
No, you haven't been sentenced on that yet.
Okay.
We held off the sentencing to do them all at the same time.
Gotcha.
So we're gonna sentence you on that case right after this, along with the other two.
So no.
So no other courts, you're on probation, okay. I do know you have the other case here, and as I just said, we're gonna proceed to sentencing in all three cases. I do, as the judge, also have discretion if I impose a prison term in that case to run that concurrent or consecutive with these two cases. You understand that?
Yes.
So with all three cases together, there's a maximum possible prison term of 3 years in prison. You understand that?
Yes.
Now, if a prison sentence is imposed in either of these cases that we're here for now that you're pleading to, upon your release from prison, you could be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you serve the prison sentence. And with these two cases, it could be up to possibly 2 years post-release control. Do you understand that?
Yes.
And if you were ever on post-release control and you violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall total or maximum, up to a maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentences I just mentioned, there's other sanctions that could be ordered. You could be fined in each of these cases. Each case carries with it a possible fine of up to $2,500. So it's a maximum of $5,000 between both cases. I could order that you pay court costs. I could also order that you reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable with any of these cases. Do you understand that?
Yes.
There's also a possible driver's license suspension in each of these cases up to 5 years. I don't have to suspend your license, but I have the ability to, or authority to do that, I should say. Do you understand that?
Yes.
Okay. Now, a few moments ago, I explained the possible prison sentence you face in each case, maximum of 12 months on each case. But when I did that, I used the word possible because prison's not mandatory with either of these cases. You are eligible in each case for probation or what we do call community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically get probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented to the court. Then I'll make the decision that I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control sanctions, it could be up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you're on probation in this court and you're violating any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions, including order that you serve time in jail, or I could terminate your probation and send you to prison at that point. And if I did that, again, that could be up to 12 months on each count, each case. Can all be consecutive. So with all three cases, 3 years, with 2 years in the two that you're pleading guilty to here right now. Do you understand that?
Yes.
That could also be consecutive to any other prison sentence you may be serving at that time if some new case arose or that you're being sentenced to at that time. Do you understand that?
Yes.
Lastly, at the sentencing hearing in this case, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just that. It's a recommendation. I don't have to follow that if I didn't think that's what should be done. Do you understand that?
Yes.
All right, well, do you have any questions for me then regarding the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences?
Yes.
You still want to plead guilty?
Yes.
Have you had enough time to talk about the case with Mr. Watson and have him review everything with you and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, did any questions for me at this point regarding anything we've just talked about, what you're pleading to, the rights you're giving up, penalties you face, any questions?
No.
Do you need any more time to speak with Mr. Watson?
No.
So what's going to happen at this point, then the prosecutor is going to explain for me, for each case, and we'll do one at a time, what the facts would show if we had a trial. I want you to listen to him, because then I'm going to have some follow-up questions for you about that, all right?
Yes.
Mr. Geigerich, let's do the 879 case first.
Thank you, Your Honor. The evidence would show that on June 7, 2025, the defendant was traveling in a vehicle that was subject to a traffic stop by the Paynesville Police Department at approximately 31 Fern Drive in the city of Paynesville, Lake County, Ohio. The defendant was the rear passenger. He was arrested on an outstanding warrant and search incident to arrest. Located a baggie in his right front pocket and a digital scale in his right front pocket. The defendant acknowledged to the police officers that the cocaine was his. It was sent to Lake County Crime Lab where it tested positive for cocaine in an amount of 1.98 grams, and the scale tested positive for cocaine residue. I mentioned the scale because it's going to be voluntarily forfeited. Oh, that's it. Thank you.
Thank you. Mr. Hemming, were you able to hear what the prosecutor had to say regarding what he believes the facts would show in this particular case?
Yes.
What, if anything, did he say about those facts he presented them? Are they true? Did you do what he said?
Yes.
Very well, then regarding count 1, charging with possession of cocaine and felony of the 5th degree, what is your plea to that count?
Guilty.
All right, Mr. Geigerich, let's move on to the 1281 case.
Thank you, Your Honor. The evidence would show that on July 22nd, 2025, the defendant was subject to a traffic stop by the Kirtland Police Department at State Route 306 in the city of Kirtland, Lake County, Ohio. The defendant was the sole occupant of the vehicle. He was found not to have a driver's license and driving under suspension. The defendant was arrested. A tow was requested. An inventory search of the vehicle yielded a bag with white powder residue in the center console and a straw with residue under the driver's seat. These items are sent to the Lake County Crime Lab where it tests positive for cocaine in an amount of less than 5 grams. Thank you.
Mr. Hemming, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show in this particular case if we had a trial?
Yes.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Very well, then regarding count 1 in case 25 CR 1281, charging with possession of cocaine and felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time 2 documents. They're both called a written waiver of guilty and judgment entry, and they set forth everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand this document, each of them, and you sign them here in court. Again, my understanding is before I came out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate?
Yes, Your Honor. I did, in fact, review each written plea of guilty form with my client. I read it. He read along with me, indicated he understood it. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Hemming?
Yes.
You understand what the documents say?
Yes.
You have any questions for me about it?
No.
Now, it also appears in each of these cases that you signed each of these. Did you, in fact, sign them?
Yes.
Mr. Watson, you witnessed that?
I did, Your Honor.
Mr. Geigerich, you didn't sign this one.
Oh.
For the record, that was 879. All right, this time then the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty in case 25 CR 1281 of count 1, possession of cocaine, a felony to the 5th degree in violation of 29-2511. Also accept the defendant's plea and find him guilty in case 25 CR 879 of count 1, possession of cocaine, felony to the 5th degree in violation of 29-2511 of the revised code. As in regards to each of these cases, I will incorporate the pre-sentence report that was completed in 25 CR 403 case, and that'll be incorporated into both of these cases. So with that done, Mr. Watson, is there any reason not to proceed to sentencing in all 3 cases at this time?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. Mr. Hameen has a drug problem, Your Honor, and I know he may not fully realize it. I know he may have downplayed it, as a lot of addicts will do. They don't think they have a problem until they get in trouble, until bad things happen. But Mr. Hameen recently lost his younger sister, and that really threw him over the edge. I know these 3 cases were essentially back to back. They were pretty close in time to each other. He has taken full responsibility for it. I mean, he's pled guilty. He wants to get his life in order. He's got family here today in support of him. Mr. Hameen knows that this court has a lot of discretion as to what it can do, but he's expressed to me that he would really like an opportunity at treatment. And I told him that it's not that he's just going to get out today and show up to a treatment center and go back home, that it's going to be, an in-depth process. There's probably going to be, inpatient or whatever if the court decides to go that route. And Mr. Amin told me, wonderful, that's what I need, that's great. He would welcome it with open arms. Judge, I don't think Mr. Hameen is an evil, bad person. I think he's actually a good person who's got a serious problem. And I'm hoping that these series of events are a true wake-up call for him. I know his history may not indicate that he's amenable to community control, but I think his attitude now will show the court that he is, if the court gives him that opportunity. He knows he's facing a lot of time in prison. The court made it very clear just now, but I think if the court gives him that opportunity, he's going to show the court that he can do what needs to be done and stay sober. I'm respectfully asking the court to take that into consideration. Thank you, Your Honor.
Thank you. Give me 1 second, please. Mr. Hameen, you have the right to address this court before you're sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes.
Go ahead.
I'd like to say I take full accountability for my actions. And I understand I have a drug problem. Not that it's an excuse. But a couple days before my change of plea court date, my little sister passed. She was a twin. She passed, giving birth to twin boys in Arizona. Well, like anyone else, when they get bad news, I got low. It resorted to
You can sit down if you'd like. It's easier.
You okay?
it resorted to me using. I know it was wrong. I know it's wrong for me to do so. resorted me in jail. I also like to let you know I didn't take your gift of probation for granted or to upset you by any means. I was in pain. I apologize. And I'm confident I am and I'm confident I can overcome this problem with my support system and Lord help. I also have a job waiting for me if you could find it in your heart to give me another chance at probation. And I can show you the change that we both want to see. Thank you.
Thank you. Mr. Watts, anything else you'd like the court to consider?
No, Your Honor.
Mr. Geiger for the state of Ohio.
Thank you, Your Honor. The state of Ohio would trust the court to fashion a sentence that's appropriate in this matter. And the thing I would point out to the court that case 1281 was committed while on bond in 25 CR 403. Thank you.
It was on both cases, wasn't it?
I think this one, he was arraigned, it happened 2 days before.
No,
He was
what I'm
arraigned.
saying is he was on bond in both cases, wasn't he? The last one happened in July.
Yeah, oh yeah, on both cases, yes, Your Honor.
So he was on the municipal bond in 879 and then this one, right?
Yes.
This court reviewed the pre-sentence report and investigation. I've considered the drug and alcohol evaluation that was completed. I've considered the facts and circumstances of each of the three cases, the nature of those offenses. I've considered what's been said here today by Mr. Hameen, his lawyer, prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. So the recidivism factors, the court notes in each of these cases that the defendant does have a criminal history. In case 879 and 1281, strike that. In case 1281, he was on bond both to this court and the Willoughby Municipal Court at the time he committed the offense in 1281. That's the Kirtland case. He has not responded favorably in the past to previously imposed sanctions. He's been on probation at this court before in the past. He's violated his probation a couple of times. Ultimately, he was sent to prison for the second violation. In regards to the drug abuse problem, there's certainly a drug abuse problem that relates to the offense. And he stood up here today and said he has a problem. When he went to the probation department, he denied having any problem. He said, "You didn't have a problem. You were using cocaine at some point daily. Then it dropped down to 3 days a week." You say that's not a problem. You've been using it for years. You've gotten in trouble before in the past because of it. You were using it still and possessing it while you were on bond. Condition of your bond is that you don't do that, and you did it. Now, either you got a problem that you can't help yourself, or you don't care what a judge says and you're going to do whatever you want to do. but you deny you have an issue. You didn't today, but up until today you did. What was that all about? You at the probation department telling them that you didn't have a problem with drugs. Why'd you tell them that?
I told him.
You told them that you used drugs. I'm not saying that. You told them that you've used drugs, and then you're at the point, I think, when this happened. The time was 3 days a week prior to being arrested. You told them when you last used, which I think was right before you got arrested. But when asked if you thought you had a problem with drugs, you said no, you didn't think you had a problem with drugs.
I'm pretty sure I said I have a problem with drugs. I even said I was open to treatment.
Well, other factors indicating recidivism is more likely. Again, the defendant violated conditions of his bond and both picking up new offenses as well as testing positive for cocaine, not providing a sample at the time of his interview. There's no factors indicating recidivism is less likely. Under 2913B1, defendant has previously served a prison term which overrides the presumption for probation and allows the court to impose a prison sentence without making any findings that are necessary to overcome any presumption. When I consider the whole history here, prison is consistent with the purposes and principles of sentencing. The question is, Mr. Hameen, whether you're amenable to community control sanctions, meaning whether you're able to and willing to follow the rules, comply with the conditions that are imposed, and do what you need to do to try to get back on track. You didn't succeed last time you were in front of me when we did this. But I'll give you one chance to try again. But it's gonna be a short leash because we've already done this before. I'm gonna get you treatment that I believe is necessary and will be helpful. Whether you take advantage of that and focus on it, put forth the effort that's needed, or whether you're just there to check off a box of what's required for you to do on probation, we'll find out. But if it's the latter, if you're just there to satisfy a condition of probation, you'll be back here pretty quickly because it'll show you don't care. If you do care and put forth the effort, then maybe it'll help you. And that's what we want. That's why I'm doing it. Maybe get you back on track. So I'm going to find that you're amenable to an available community control sanction for each case. In each case, you're going to be on community control sanctions for 2 years. It'll be concurrent, so it's just 2 years total for all 3 cases. In case 25 CR 403, I'm going to order the defendant serve 60 days in jail. Well, let me strike that. I'm going to order that he serve 150 days in jail. He has credit for 84. The other 2 cases, there's no jail time. I'm going to further order that upon a bed becoming available at NeoCap, the defendant be released from the jail. And in all 3 cases that he's ordered to enter NeoCap and successfully complete that program. So I've given an extra cushion of time, but whenever a bed's available, you're going to be released. If it's, I don't know, how long is the wait? Usually about a month. Yeah. If it's next week, you can get out. If it's 2 months, you're going to get out. So whenever that bed's available, you'll be able to be released. The balance of that jail time will be vacated. You're to enter NeoCap and successfully complete that program and follow all their aftercare recommendations. Upon completing NeoCap, I'm going to order, in case 25 CR 403, now you're probably not going to have to do this, but I'm going to order that you return to jail for 30 days for the transitional day reporting program. Again, good chance you're probably not going to have to do that 30 days, but what that is, it's a program that helps people make the transition from being locked up for a while to being on their own. Sometimes when people get released from custody after being in for a while, you know, they're told to leave and they have nowhere to go. They don't have housing set up, they don't have work set up, and they need help making that transition. And it's a good program for those that need it. But if you have housing set up, if you have work set up, and it's something you can get set up and work on while you're at NeoCap, if all that's taken care of, I'll vacate those 30 days. You won't have to do it. But it's a good program for people that do need that help, so I put it in place for everybody that goes to NeoCap.
And that's only on 403.
That's only on 403. So the jail time being imposed is just on 403 in both. Upon your release from NeoCap, then, again, the following conditions, and this is for all cases. You're not to use any drugs or alcohol. That includes no marijuana, nothing. You should submit your random urine screens. They must be negative. A positive screen will be a violation. Can't tamper with the urine screens. Bring in fake urine, anything like that. You attend 3 AA meetings a week and have a sponsor. To obtain and maintain full-time employment, you need to get a job and you need to work. You need to keep yourself busy once you get out. In case 25 CR 403, I'm going to fine you $100. Repair court costs and supervision fees.
Your Honor, I think the $100 was restitution. No?
I'm ordering a fine of $100. He didn't plead a theft offense, and I can't order restitution to narcotics agents for that. There's case law on that.
Okay.
So basically, once you get through a NeoCap, just don't use drugs, follow their aftercare recommendations, and work. That's what the plan's going to be. Kaylee, is there anything else I'm missing here I should think about?
Your Honor, I'd like to consider one doctor, one dentist, and release.
I don't think that's necessary here.
No releases to be signed.
Well, I'm not ordering the one doctor, one dentist.
Okay.
Well, I'll sign releases for counselors and that. Yes.
Thank you.
Sign whatever releases they need in terms of being able to speak to your counselors. I thought you meant for the one doctor, one dentist. I'm sorry.
Okay. Thank you, Your Honor.
Anything else?
No, Your Honor, thank you.
So, Mr. Amin, you understand the conditions of your probation?
Yes.
Let's do this for the record, just so the record's clear and it'll be easier. Hopefully you don't have to worry about it. In 1281, I'm going to order that he serve 58 days of jail with 58 credit. Just so the record shows. In case 879, 3 days of jail with 3 days of credit. So it's no more jail time, it's just the time you've already served. Basically giving you the credit for that. I need to advise you that if you fail to comply with any of the conditions of your probation, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, you can extend your probation in each case up to 5 years. You can impose more restrictive sanctions against you, or I can terminate your probation and send you to prison. And if I sent you to prison, in each case it would be 12 months. Each case would be ordered to be served consecutive to each other for an overall total of 3 years in prison. So that's what's hanging over your head. You understand that?
3 years.
Total of 3 years with all 3 cases. 1 year on each case. And all 3 would be consecutive. So it would be 3 years in prison is what's hanging over your head if you violate your probation. You understand that?
Yes.
And for the record, that would also be consecutive. It could be consecutive to any other prison sentence you may be serving on some new case you pick up, or you're being sentenced to at that time if that were to happen. You understand that?
Yes.
All right. Mr. Geigerich, I'll order the voluntary forfeiture of any contraband or meaning drugs or paraphernalia that was seized. Anything else, Mr. Geigerich?
Just so it's clear, for the remaining files, besides the jail time credit, you're starting with the no drugs, alcohol screens, 3 days a week. So the NeoCap has nothing to do with the 2 new.
No, NeoCap has to do with all 3 cases.
Oh, okay. All right.
No, NeoCap is, the only thing that's specific to 403 is the 150 days of jail and the TDR.
Perfect.
Everything else is all 3 cases.
Got it. Thank you.
You want to say anything else?
Nothing further, Your Honor.
All right, thank you.
Okie dokie. Let's go back to Judge Boyd. The argumentative attorney is walking back up.
Give us a moment. You all have put on here that you're contesting the total amount owed for restitution. You're not, because you all agreed that she owed the amount to the junior league. Am I right? So
Right.
that's not contested.
Right.
So
Judge,
if
if I
you want to
may,
put that in there, you need to put specifically what you're contesting. If you're contesting the insurance company, then you should put the insurance company in there. Otherwise, you're saying you're contesting
Judge, may I,
junior league.
may I address?
Sure.
Because I'm the one doing this, not
Okay.
Chandler, so, Judge, what we're contesting is just the final total amount that are in the documents that are contained in State's Exhibit 1. And so that's what I'm trying to put on there, that we're contesting the total amount that they're saying is owed.
So you're contesting the amount that they're saying is
just
owed
saying
to
it's-
Berkshire Hathaway and Visa?
Yes, indirectly. I mean, in the documents, Judge, in the State's Exhibit, it has that she owes, that the total amount for the funds that were taken were 11,000 something, okay? We agreed to make a payment of the 1,077.01 upfront, but we have never, and we don't want to in the paperwork to stipulate that the 11,000 number that's in the State's Exhibit documents is a correct number. We believe it's lower. So that's the only issue. And Judge, and the reason why I want to have this in the paperwork is because if we're requesting that you not order a restitution hearing and let the third parties handle that on the civil side, where they can get accountants and they can really dig into that. And so if we stipulate to the true and correct nature of all of the State's exhibits, that includes that 11,000 number, and on the civil side, then there's nothing for them to, have accountants come in and.
So this is what I'm telling you all. When you say you're not stipulating, you're stipulating to everything but the amount, you're including the amount to the junior league in that. If you want to put in there
Okay, I can put in-
something else to address that, you can put that in there. But when you all say you're not stipulating to any amount, then she's not even stipulating to the junior league amount.
Okay. We can put in there to owe to third parties.
Well, the junior league is a third party.
Well, the junior league is the complainant. They're not a third party.
What I'm telling you is the parties are the state and the defense.
Right.
Well, your client, the state and your client. The junior league technically is a third party. So whatever is in there that you all are not stipulating to, which it appears to the court from your plea bargain agreement, the only thing you're not stipulating to is the amount to Berkshire and the amount to Visa.
Yes, Your Honor.
Is that correct?
Yes.
So
And
why
that's
is
below
it?
the line anyway.
So why is it hard to put in there? We are not stipulating to any amount owed to Berkshire or Visa. Why can't that be added? If that's the total amount.
I can do that, Judge.
Okay. Thank you.
Thanks, Judge.
Do you want us to print this out again, or can I just change the language?
You'll have to write it in there and then have her re-sworn by the clerk. All right.
All right, let's go to Louisiana. Let's do one of those.
Today's date is 10/23/2025. My name is Chuck Tillis. My colleagues are Mr. Jerry Ledoux, Miss Jerry Ledoux, and Mr. Steve Prater. We're at the DOC headquarters here in Baton Rouge, Louisiana. Staff, introduce yourself.
Jasmine Thompson.
Devin Cavalier.
Carla Williams.
Okay, our remote locations at the Calcasieu Correctional Center. Would you state your name and DOC number for the record, please?
Kyle Joseph Natali, DOC number 632078.
Okay, and I see you're represented with your attorneys.
Yes, sir. Adam Johnson, bar roll number 32515, and Mr. Fred LeBlue is here with me.
28654 is my bar roll number.
Okay, thank you so much. Ms. Ledoux will be handling your case today, and she's going to ask some questions, and then I guess she will get with the attorneys to get their information from them.
Yes.
Okay.
Thank you, Mr. Chair. Good morning, Mr. Natale. I'll start off by saying that I have received in our packet the letter from Adam Johnson regarding the recent court hearings that you've had on this matter. And I will still ask you, I'm going to read the allegation against you, and I'm still going to ask you for a plea, and you can decide how you want to answer that. Guilty, guilty with a statement, or not guilty. It's alleged that on 1/19/2025, you engaged in new criminal conduct and were consequently arrested by Lake Charles Police Department for operating a vehicle while intoxicated, fourth offense felony, and obstruction of justice, a misdemeanor. The pending charge had been set initially for 10/8/2025, and it is still continuing. How do you plead on that?
Plead not guilty.
Mr. Natale, were you arrested on 1/19/2025?
Yes, ma'am.
Okay. It's my understanding at that time you refused field sobriety test. Is that correct?
No, ma'am. No, ma'am. That's not correct.
Okay. I do have logged into the evidence in our file the results of a blood alcohol draw. At this time, I will allow Mr. Ryan Natale, your brother, to make a statement on your behalf.
How's everybody doing?
Fine.
I'm just gonna speak on behalf of Kyle. As I said in my letter previously, we grew up in a household and became split at a young age. I kind of sided with my mom. We're 7 years apart. So he's 7 years older. He sided more with my dad, who was, physically, mentally, financially abusive, was, on substances, alcoholic, all the things. He left home when I was 2. He moved to Lake Charles while we lived in Lafayette. My brother kind of went with him, kind of was his mentor in obviously a negative way. I sided with my mom. I mean, she never was in any trouble. She just was, a regular person. Through that time, he visited home a lot. My brother's my best friend in the best way. He's smart. He does everything I know today is really on him. I wouldn't probably be where I'm at if it wasn't for him. He has, outside of any trouble, he's the best guy. Everybody for where he works. I think he's been incarcerated for, I think it is almost 11 months, and I think he's almost still kind of guaranteed his job. His boss texts me once a month asking about an update on him. He's well liked. He's a great brother, great son. Everybody, he has a huge support system. He's the best person you can ask for, really. Just, one of those things that a little help wouldn't hurt. Treatment and everything, he'd be the best person that you can ask for.
Thank you, Ryan. I did read your letter. I appreciate you being with us today.
Thank you.
I think at this point, if the attorneys, Mr. Adams and Mr. LeBlue would like to make a statement to the panel, this would be an appropriate time.
Sure, I appreciate it. You can hear me okay?
Yes.
Okay, I'd just like to thank the board for its time and service to Louisiana. I know that this is a tough job, but we certainly appreciate the opportunity to be heard. Ms. Ledoux, it's certainly, I hope, an advantage that we have someone with your experience, and we have the rest of the board members who obviously are very, very experienced and have been working in this area for a while. We are requesting deferment, just as we requested deferment at the preliminary hearing. When we appeared at the preliminary hearing, Mr. LeBlue appeared on my behalf and requested that we continue the matter because I was in federal court, could not be there, had been summoned to federal court. That was denied, and we were told by Mr. Vidrine that that a new law had been put in place and that deferment couldn't be requested. We did recently run into Mr. Vidrine, and he informed us. He said, "Look, I think that was actually an error." So to his credit, I think he's corrected himself. But we are requesting deferment. If not allowed to defer, we are requesting that the board recess after the hearing, allow the record to be remained open for us to submit some additional documentation that we just recently received, and reserve ruling until the disposition of the pending criminal charge. I believe this is allowed. Either of these options are allowed under board policy 11-1115. Again, I appreciate the opportunity to be heard. Mr. Natale's case is complex in as much as he has 3 different matters pending, but I'm sure that you've all seen this before. I'd like to explain a little bit. We have the parole revocation, which we're here for today. We have a pending probation revocation hearing that's been deferred. And we have a new criminal charge. And all of these instances are based in part on the allegations of the new criminal conduct, namely his being arrested as Ms. Ledoux described for a DWI, a 4th offense in Lake Charles on January 19th. In terms of the proceedings that we've had thus far, we've had a hearing on the revocation of probation on July 16th. At that revocation hearing, there were several pretrial motions, and I would have considered that kind of like a mini trial. There was a motion to suppress heard, a motion to quash heard, which resulted in the judge hearing from the arresting officer, from the lab technician, and the judge, the same judge who sentenced my client on the previous case for which he is now on parole. That judge deferred ruling on the probation revocation, and he suppressed all evidence in the case for a variety of reasons, including the improper handling of evidence, no probable cause for the arrest, intentional misrepresentations in the search warrant, among others. Kyle's case is extremely unique in that the video evidence and testimonies shows that prior to being stopped, the police officer's dash cam shows no bad driving at all. And he is immediately arrested despite his cooperation, essentially because it was cold outside that day.
He did offer to.
And at the scene, thank you, at the scene, when asked if he would do standardized field sobriety tests, he specifically stated he would and was willing to do same. Despite that, the police officer represented in his arrest affidavit that he refused standardized field sobriety tests, which is potentially resulting in additional confusion today. Officers put him in the back of the car, and once his history was realized, they got a warrant based on intentional misrepresentations, disengaged the body cams, and it's an extremely unique circumstance in the sense that they held him for several hours. They allegedly took blood. There's no video of it for 5.5 hours. And the police officer who took the blood left the police department with the blood in on his person for several hours prior to returning back to the station. None of which, very little of which is actually on camera. For all of these reasons and more, the judge in this case, again, deferred ruling on the probation violation and suppressed all evidence in the case. We quoted the judge in our letter to say that he had thought about, why do I need to wait, even though the defendant has a previous conviction for the type of conviction he has. The state took a writ to the 3rd Circuit. The appeals court reversed in part, but did not address the handling of the blood and remanded for the court to consider some cases on the search warrant issue. And we are currently drafting a writ of certiorari to the Supreme Court. the judge has continued the probation violation hearing pending our filing of the writ with the Supreme Court. The benefit of this info is that the judge who hasn't violated the defendant's probation and has suppressed the evidence has heard significant live testimony in the case. Additionally, I would point out the defendant's fourth offense charge is not actually going to be a fourth offense charge, but a third offense charge, and this makes up part of the information that we would like to send the board should it not allow us to defer. Having said all of this, I believe it is extremely likely that Mr. Natale committed no new criminal activity, and he would like the opportunity to continue defending himself before suffering additional ordered jail time, hence our request for deferment. If we are able to resolve the criminal case without a conviction, but my client's parole is revoked today or before the criminal case is resolved, I think such is unnecessary at this stage with his already being incarcerated. If his criminal case results in a conviction, his probation will be automatically revoked, resulting in him serving his original suspended time on the underlying conviction, together with additional time on the new conviction, which will exceed his parole time in this case as well. Accordingly, that is why we're asking that the board in its ruling defer its ruling on parole. In the alternative, recess the hearing, leave the record open, and allow us to supplement the record and defer its decision or withhold its decision until disposition of the criminal charge. Finally, as a third alternative, we ask that the defendant be committed to a community rehabilitation center or substance abuse treatment program pursuant to the board's policy outlined in Title 22. The sanctuary exists. It's not far from our current location. In the event my client is sent to treatment for up to a year, this would give time for his criminal matter to resolve, would provide him with necessary tools all of us need to survive and be successful post-incarceration. And if ultimately convicted, because he is a young man, his receiving treatment would harm no one and reduce any risk to the public in the future, while also not unnecessarily punishing the defendant prior to his criminal case being resolved in the court system. If convicted, he will serve additional time beyond that required for the parole violation because of his probation and required suspended time. So treatment here with the chance to return to supervision does not harm anyone, in my opinion, and is, in my humble opinion, a responsible alternative should deferment or withholding the disposition not be allowed. I want to thank his brother, Ryan, for appearing and his support. His mom and dad are also standing close by, as well as his grandpa. That's all I have at this time. And I appreciate the opportunity to be heard, Ms. Ledoux and the other members of the board, Mr. Prater and Mr. Tillis.
Well, thank you, Mr. Adams. You're prepared as usual. I would like to ask my colleagues if they would like to ask some questions at this point.
They're not.
Okay, Mr. Tillis?
I'm good.
Okay. Let me just reiterate a few of the facts of the case that I believe should be considered in our decision and will be considered in my decision. Mr. Natale was sentenced to a 10-year sentence, and which was the result of a plea bargain, and served 2 years, 8 months on that sentence. That was a significant break for a vehicular homicide case, in my experience. The contentions of the mishandling of evidence is not something that, as a panel, we take into consideration in terms of the legality of it, because we have a reasonable expectation that the preponderance of evidence leads us to believe that a violation has occurred. Based on the police reports that we have before us, and trust me, I've read them in depth. I've listened to the conversations. I've done due diligence on this case. Mr. Natali had a blood alcohol level of 0.167 that is attached to this case. And so, in my mind, those are, I've read all the police reports, and you have the right and will and have challenged those. However, today, that is what our decision must be made upon. So without my colleagues having any other statements, I would ask Mr. Natali, would you please give us a statement in your own words about this situation?
Yes. So and I can tell you, as an officer as an attorney and officer of the court, my client wants nothing more than to speak about, to be able to speak freely just in general. The issue that we have is that he's currently being prosecuted by a prosecutor, and these meetings are recorded and they're broadcasted online and they're available to the public. And so my fear is that asking him to specifically comment on the allegations that he's facing that are right now in the court system and may very well be pending trial at some point, or are pending trial, but may very well be pending trial, could cause him, if he stumbles or says something, because you can be completely innocent, but you can still incriminate yourself if people believe you've committed a crime. And so I hate to do that, because I know that's not what you guys like to hear, because I get it, it's separate, but that is unfortunately my job. And that's just another reason that we're asking for a deferral, and that the record remain open. And that while we're also pointing out that since he's already incarcerated, that to do so would not put anybody at risk or jeopardize anyone's rights, regardless of how informal those rights are, whether in front of the parole board and its decision-making process or in the criminal court system. I hope you respect that answer. That's the best I can do.
Absolutely. That is your role in this hearing, and is respected. If the panel has nothing further, I appreciate your position, Mr. Adams, Mr. Johnson, and Mr. Natali. But today, based on the evidence that we have before us and the way that we review our cases, and my vote is going to be to revoke parole. And he's, parole is a gift, as you both are very well aware of. And he did have a 10-year sentence, and my vote is to revoke. Thank you.
Mr. Prater?
With that, I think there is a preponderance of evidence that this occurred. And I think for the protection of the public and Mr. Natali, that I think the best place for him right now is to have his parole revoked, that he be placed in and get some long-term substance abuse at a DOC facility mandated, and that he should not be released until that's completed. That's my vote, revoke.
And I also concur with my colleagues. So today your request has been denied.
Denied.
9:15.
So good job by his lawyer stepping in there, but the result was not all that surprising. So we are into overtime, my friends, but we're going to do just a couple minutes more overtime to finish things up, because argumentative attorney is stepping back for round 3 in front of Judge Boyd. So we'll finish with that.
All right, and now you, Ms. Madura?
Yes.
All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, according to the plea, the state is waiving count 1, proceeding on the lesser included offense of theft, $750 to $2,500 under count 2. They're recommending deferred adjudication. There's restitution of $1,077.01 to the Junior League of San Antonio through the DA's office, and that has been paid. Is that correct?
That's correct, Your Honor.
Did you understand that to be the plea?
Yes, Your Honor.
State?
That's right, Your Honor.
Defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be restitution of Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense under count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Well, for Exhibit 1 with all attachments.
Any objection?
No objections, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state would not be calling witnesses? Their evidence would be in the form of witnesses' statements, police reports, and bank records. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Dave, to be clear, we did not lose sound. The judge is reviewing her paperwork here at the moment, so she often goes through these periods of silence, but we'll stick with her, and then once we have her final rulings here, we'll call it a day. Thanks to everybody for joining me, though, by the way, today and hanging around for overtime. Surely appreciate it. I will say this, the amount of review going on here is absolutely impressive. Normally she's through things in like 30 seconds. This feels like it's been about 4 hours. Wahoo, insert Jeopardy theme here. I would if it wouldn't cause a copyright claim. I would absolutely do it. But, you know, Sony will want their money because they're a greedy corporation. And I'm a capitalist, and I'm telling you they're a greedy corporation. So yeah, hum it in your heads as we continue to wait.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right, with regards to the amount that's outside your agreement, we'll come back for a hearing, and at that time, I'll sentence.
Okay.
All right, Ms. Ferguson, I need a reset date. And this is just for restitution?
And Judge, are we going to have a full restitution hearing? If so, we're going to have to get a forensic accountant. I'm not an accountant, to go through all of the documents and bank records to prepare for that hearing. Your Honor, I would respectfully request if you would not order restitution or not make a decision and not have a hearing and let them handle that on the civil side in the civil courts.
Yeah, I'm not going to do that.
If I may respond briefly.
Yes.
Just the state's theory that amount be assessed as restitution is that is an amount the defendant received the benefit of. She can't keep.
I'm sorry?
She can't keep that benefit.
Okay. All right, we'll set it for a restitution hearing. Norma, I need a reset date for a restitution hearing.
And Judge,
You're out 45 days.
Just to make it clear, we're not requesting that she keep anything. We are requesting that we get to the correct amount.
Okay. All right, we'll be back on December 11th. Once you sign the reset form, you're excused, and on that date, I will sentence. All right, thank you. You're welcome.
You need anything else from me, Judge?
No, that's all.
Y'all have a great day.
And would be excused, Your Honor?
Yes, once she signs the reset form.
Yes, please be excused. Get out. Go away. Wow, that was a lot of arguing for what seemed like routine to me. I don't know. But you all had a lot to say about it in the chat, and I don't blame you. So that brings an end to today, folks, with 18 minutes of overtime. Thank you so much for joining me. I hope you had fun today. The special guy who was in front of Judge Simpson, that video has already been removed from the judge's feed. However, I did capture a clean copy of it before he did. So that will be a video probably up tomorrow. So be sure to be on the lookout for that. Speaking of tomorrow, we'll see you then, 10 a.m. Eastern, 7 a.m. Pacific. But before that, we will see you tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, where we will be talking about sovereign citizen kind of stuff, much like what we saw in Judge Simpson's court today. So be sure to join us for that. In the meantime, go have yourselves a great Thursday. Make the best of it. This is the only Thursday, October 23rd, 2025 you'll ever see. So make it the best it can be. Take care. God bless.